Greetings, 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 greetings. Desire your King, King Clifford Jefferson, the Senator Godfrey, the fifth kind of band Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of Jesus Christ, which we know here in the English Church of England is King Edgar the Peaceful, better known as the King of Peace. I'm here to renew your story. Uh, as I've been in regards to the creation of this platform, which is the forum for the English Third Temple Church of England, going back to time immemorial, a time out of mind, which we know not of. But today is going to be a very, very, very important lesson for all those who are viewing it, who have any concerns about their well-being. This is the time to take notice. All right. Once again, most of the things that I've shown you have been concrete. Uh, these things are being pursued and being formulated in a intelligent format, where as though some type of release can be given to those who are English subjects of the Kingdom of England, which is domicile or now termed United States of America. All right. Once again, this is a lesson that you will not want to miss. All right. So, um, as always, I like music when uh, uh, I'm actually giving a lecture because I like to put you in that frequency. So in lieu of not being able to present that, I put your mind in at ease and rest assured that everything is being taken care of in regards to the English nation, the English people. All right. Uh, I suggest all those who have the other platforms, Sinetta TV, Sharon Sunseti, the Hebrew Israelites, Canaanite Temple, Moorish Science for America, uh, the Rastafarians, the Israelites, Hamas, um, uh, United Kingdom, Euro Africa, Native American Indians, Moors, uh, anyone that you can think of at this particular time to what's going on, uh, pursuant to what's going on around the world, is going to be affected by the changes that are coming. All right. I'm going to show you. I tell it a lesson to be able to show you that in modern day, and which in your calendar is November the 8th, 2023, which in the Burberry is 2973. And I'm going to show you that, and I'm going to correlate that, and I'm going to pursue that in the interest that's best befitting a conversation that measures up uh, uh, to a height that none has been able to meet. Um, Once again, I'm very fortunate. You know, there's a saying that the Creator speaks in the still small voice, and he who listens is still. Um, Once again, this is going to be a lesson that I'm going to show you. All right, and we know when it comes to uh, bringing relief to a nation or a country, or and those communities that make up that country, that's called by a nation or by their national name, it takes time. You know, majority of the remedy that's created for the public domain is rooted in the legislation. All right, the legislation is that presented on behalf of those who represent the people. All right, and here in North America, people are not associated with genealogy or ethnicity, as we see by the Naturalization Act of 1790. And we know that on the federal and the state level, most citizenship is perceived in that guise. All right, which has nothing to do with any genealogy or ethnicity test. And we can go on for days to talk about that. But the application for which this lesson is being presented is regards to law, legal standing in law, in regards to you being a nation of people to right to be able to dwell on the land that belongs to you as a result of it being subject to what we call public trust doctrine. All right. This lecture is about the public trust doctrine. And you should be familiar with this public trust doctrine because this deals with all that which has been placed in the trust. You call it a cestui. All right. All this goes back to my forefathers. All right. And I'm bring a full circle to you. All right. And I'm going to show you the authority that the English Third Temple Church of England has by way of their incorporation through their certificate of corporation as required by the statute, in lieu of what we call under the authority of what we call the crown, through what we call the corporation sole. And we know the corporation sole, which represents the crown, it has the authority by way of jure regalia of the crown to be able to uh, uh, dispose of property that falls into what we call escheat. All right, because we know that interstate is a result of there being no heirs, which results in a loss of hereditaments. Hereditaments is very important to recall what we call a birthright here in what we call North America, because everyone here in North America in this present day to the formation of this nation uh, claim to have some type of rights, but the rights here does not come from birth. It comes from that which came through what we call the right of discovery. All right, either right of discovery, which is no other than right of conquest, because we know right of discovery was preceded by right of conquest, which started with the House of Tudors through Henry VIII. All right, everybody should be familiar with Henry VIII. He was the son of Henry VII, the founder of the House of Tudors of the Lancaster branch, cadet branch of the Plantagenet. All right. So without further ado, let's get busy. I hope all of y'all who are faithful. Your name will be recorded in what we call the new ministers Liber Vitae, which is the Book of Life. All right. And I did a lesson on that. For all those not familiar, look up that. We know that King Edgar the Peaceful fit the description of in regards to the image of Christ. He was the personification of Christ, or the incarnation of Christ, or the incorporation of Christ through what we call the corporation sole, contrast to corporation aggregate, which the United States, the states, and the colonies consist of. They were nothing more than corporations underneath what we call a charter. A charter is a letter patent issued by the king. And if it's not issued by the king, then that means that the only letter patent you can receive is that it was issued by the state through statutory law, which means that you're a creation of the state statute. All right? Very, very, very important to understand that. So let's get busy. All right. As you can see, our authority, book and page number, all right, filed in the Middlesex County of New Jersey. Filing fee required was paid. We're listed as a religious society, a corporation sole, New Jersey Revised Statute 61-28. All right. Date documented April 18th, 2022. If we go scroll down under our authority, there's our logo, certificate of incorporation, the Third Temple English Church of England, King, heirs, and successors, a corporation sole. All right. Province of New Jersey. We know the province of New Jersey was ruled under the provincial council, which represents the crown. All right. So as you can see, business type, this is corporation sole of royal peculiar, representing the crown. Business purposes. It means for orderly transfer of ecclesiastical property, serving to keep the title within the denomination of our religious society in order to keep the religious property from being treated as an estate of the vicar of the Roman Catholic Church. The property was titled to the office of the corporation sole. A corporation sole, the crown is the legal embodiment of the executive, legislative, and judicial governments in the monarchy of each commonwealth realm. All right. Article 4. Members' purpose. Magna Carta Clause 1, the liberties of the English Church, first, that we have granted to God, and by this present charter to have confirmed for us and our heirs in perpetuity, that the English Church shall be free and shall have its rights undiminished and its liberties unimpaired. as the English kings, heirs, and successors, duties, and allegiances to restore the period's life and history of English, Anglo-Saxon, Berbers, the English Church, our customs, our laws, our traditions, our religious belief, back to time immemorial here in America, to commemorate our saints, martyrs, and our past kings and queens, and restore the mysteries of King Edgar the Peaceful, known as Jesus Christ. All right? Very, 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 very important to understand that. All right. So there you see our certificate of incorporation, i.e., our charter, and it's recognized due law underneath what we call legislative statutory law. All right. Let's review that real quick. Corporations, associations, religious section. 61-28, saving the rights under charters granted by Great Britain. We know the charter is a letter pattern. All right. We know under Title 14 of New Jersey by statute, corporations, businesses, partnerships, and those types, corporation aggregates are formed that way under Title 14, contrast to Title 16, which deals with religious society. And this statutory legislative law, which i.e. the common law, actually states under the revised statute law of 1877, this is being Section 12 of an act to incorporate the trustees of religious societies, approved April 9th, 1875, saved from repeal, meaning that you can't change it. This section vested property held under charters of incorporation granted by Great Britain and corporations and created in place thereof. All right. So the corporations who hold the property that was held under trust from the kings of Great Britain is the United States, because the United States is a corporation, and the United States descended down from the 13 colonies, which was the 13 original states, which were at that one time, prior to that time, were called colonies, under the authority of the Crown, under the Provincial Council, under the province of New Jersey, which the Crown rules is perpetual. All right? So on the rights of the charters of Great Britain, we have enacted through our certificate of corporations as trustees, as those that were under the authority of the Magna Carta going back to time immemorial, pursuant to the rights saved under Great Britain through the unions of the crowns in 1603, and as well as the result of the Treaty of Union of 1707, which united the Parliament of England, Ireland, and Scotland, still separate, but created together under the ruling monarchs at that time under the British Crown, because you had the English Crown, you had the British Crown, you had the Irish Crown. All right. And the English Crown still rules here, and the territory is known as what we call Channel Island, now called Jersey, i.e., New Jersey, which you see the flag here represents. All right. But that goes back to the understanding of the Duchess of Normandy. All right. But as you can see, rights saved under the charters of Great Britain, saved from repeal, an act concerning property. That takes us to Title 46. All right. But before we go to Title 46, we're going to go to Title 1643, 43, what's it? 43.9. 16, 16:1, that's 43.9. Powers of the consolidation of corporations in regards to religious societies. Because you see, we were incorporated under 16:1-28. So this is a power as a result of the incorporation. It says, ask your leaders, your scholars, your teachers, your religious leaders, those who, your government officials, your administrative officials, your county electives, your state electives, your federal electives, your judges, the executive branch, the legislative branch, under what power of incorporation did they come into existence? Because all of it was created through their constitution, which limits their authority. But the Constitution of the United States is preceded by the Constitution of the state of New Jersey. All right? Because we know that the United States Constitution of 1789 is pretty much modeled after the Constitution of New Jersey of 1844, which proceeded from the Constitution of 1776, which at that time was a constitution for a central government, not the general government, but the central government, because the general government was under the authority of the Crown. Okay, so under that authority of the crown, as under the crown corporation, because all corporations under the letter patent or the charter is given from the king. All right, very important to understand that. All right, the powers of consolidation of a corporation under the New Jersey revised statute pursuant to those dealing with Great Britain, because we incorporated under 16.1-28, right, state under the charters of Great Britain. As you've seen it in the language of the certificate of incorporation is no different than a charter, pursuant to the language in this statute. The consolidation corporation shall have and may exercise all powers conferred by the respective certificate of incorporations or charters of the constituent corporations. By Title 14, corporations in general, or by Title 16, corporations, associations, and religions. So choose, take your pick. Is it going to incorporate by Title 14 and United States incorporated by Title 14, not Title 16, because of the separation of church and state. All right. By Title 16, corporations, associations, and religions, and in particular, the powers conferred by Article 5 of Chapter 1 of Title 16 of the revised statute, so far as the same are not inconsistent with this act, are necessary or convenient to the furtherance of its object, and are in accordance with the doctrine, government, discipline, and uses of the church or religious denomination, to the jurisdiction of which the constituent corporations were subject. It shall have, among other powers, the power to invest, change the investment of and reinvest its endowment and funds in such an investment, whether or not prescribed by statute, in such a manner as it shall deem proper. All right, that's under 16.143-9.9. Let's go to 46 colon 46:7-5 of the New Jersey revised statute dealing with property, because we are talking about property that belongs to Great Britain, held by charters by incorporations of place thereof, i.e. the United States, i.e. the federal states, the states known as colonies prior to the incorporations as states, and to the United States, which is nothing more than the 13 colonies. The statutory language of New Jersey revised statute 46:7-5 says, conveyances to religious societies prior to the incorporations valid after incorporation. You hear that? Where any conveyance of real estate has been made, executed, and recorded in favor of any religious society, association, or corporation of the state, as the grantee therein, and such religious societies, corporations, or associations has failed to record and file the proper certificate of incorporation in the manner prescribed by Title 16, corporations, associations, and religions, or by any law enforced at that time when any such society, corporation, or association was incorporated or attempted to be incorporated until after making an execution of such conveyance and recording thereof. Any and all such conveyances shall be as valid and effectual in law as if made, executed, and delivered to such religious society, association, and corporation after the filing and recording of the proper certificate of incorporation, and as if made to such religious society, association, or corporation during the period of its corporate existence. And the record of any such conveyance such made to any such religious society, association, or corporation prior to the recording and filing of a certificate of incorporation, as recorded subsequent to the recording and filing of such certificate of incorporation, should be admissible in evidence as fully and completely for all purposes as of such conveyances and have been made and recorded during the corporate existence of such society, association, or corporation. It said nothing with the corporation under Title 14. This has to do with Title 16, corporations, association, and religious society. Okay, so that must be clear to all those who are watching this video. Okay, so let's go back to our certificate of incorporation. As you can see, book and page number, all right, recorded time by the county clerk office in regards to 16(1)-28. You see it there. As a corporation sole. Very important to understand that. All right, so let's qualify that. Let's move forward. As you can see, this is a case law. All right, what page is this on? Okay. This is from the United States Bankruptcy Court, District of New Mexico. In regards to the Roman Catholic Church of the Archdiocese of Santa Fe, as a debtor, all right, in regards to the filing of the certificate of incorporation of the Roman Catholic Church and the status that it falls under, all right, under the status that it falls under. And this is the ruling of the court, page 3 of 8. Debtor is a corporation sole. Debtor is a New Mexico corporation sole organized in 951. New Mexico current status do not refer to corporation sole. In 1951, however, the legislature amended a prior corporation statute as follows. Any person whom shall be vested the legal title to the property of any church or religious society in conformity with its constitution, canon, rights, or regulations, and of any scientific research institution maintained solely for the pure research and without hope of pecuniary gain or profit, may make any subscribed written articles of incorporation, and acknowledge the same and file a duplicate of such articles for record in the office of the county clerk of each county at which any real property of such corporation is situated, together with an impression of the seal, which it shall adopt. Such corporation shows to be perpetual in existence and shall vest in all successors in office to the person so complying with the provisions hereof, entitled to all property vested in such corporation so hereunder shall also vest in such successors in office. So here you see it in the district court in regards to a corporation so under the Roman Catholic Church. We know the Roman Catholic Church was head of the authority that was at odds with Henry VIII, who broke away from the Roman Catholic Church through the English Reformation of the English Church. All right. And we know that that English Church, which he represented, was a result of the conversion of the Anglo-Saxon Berbers to Christianity. All right. I taught on that prior, so I'm not going to get into that. So there you have it. You see one case, anyway, Archbishop Diocese of the Church in Mexico, which the court ruled that they were a corporation sole. Corporation aggregate. Corporation aggregate consists of many persons united together into one society and are kept up by a perpetual succession of members, so as to continue forever. Corporation sole consists of one person only and the person's successors. You hear that? In some particular station who are incorporated by law in order to give them some legal capacity and advantages, particularly that of perpetuity, which is a natural person that would not have, i.e., immortality. All right, immortality. That immortality only goes back to the understanding of immortality, where you're looking at it from an abstract or concrete. And the concrete immortality goes back to time immemorial, starting with Richard I, son of Henry II, son of Godfrey V, Count of Anjou, which rules Channel Island, now called New Jersey, as a result of George Carteret and John Berkeley, who received charges from York, Duke of York, from Charles II as the reservation of the crown when they were warring through the Third, the Second, and the First Anglo-Dutch War, which goes back to the Treaty of Westminster of 1654 and 1674, which we discussed in my prior class. All right, we're going to speak about it briefly today, but I'm just showing you some concrete, valuable information, and along with our obligation as the English Third Temple Church to speak on your behalf, in regards to your lost estate. All right? Got to understand what I'm bringing you. Okay. You talk about receipts. These are the English Third Temple Church receipts. All right? These are our receipts. These are cases filed within the district court. All right? In the district court, on behalf of the authority we have as a corporation sole. And we just heard the district court in Mexico about the authority of the corporation sole as a result of the certificate of incorporation. And we see our certificate of incorporation was based off 161-28, right, state in charge of Great Britain, state from repeal, and act to incorporate trustees for property held by corporations placed thereof. And we know the United States, i.e. the states, i.e. the colonies, are nothing more than a corporation. I'm going to prove it. All right. This is why these cases are filed in what we call federal question, all right, resulting from supreme law of the land in regards to treaties, all right, via the Treaty of Alliance, key treaty, which was the Franco and the American alliance. It goes back to all the alliances made with the Frankish dynasties who were at war with the English kingdom and the English kingdoms who were ruling France at that time under the Plantagenet crown, all right? Everybody look these docket up. These are cases filed last year and this year, which are still sitting on the docket as a result of them not knowing what to do with this case. All right. And I'm going to give you an example that the district court are ruling in regards to the authority that, because remember, the district court is a court of review. It's not a court of general jurisdiction. All right. They only review cases from the state courts. All right. The district courts or circuit courts reviews from the state court, right? And we know the state courts of every state, if you're in the colony, was under the authority of the crown, under the provincial council, all right? Under the power and authority of the King's Bench. And the King's Bench was situated in the New Jersey Supreme Court, right? And it was instilled with the King's prerogative. That's his jury regalia, to be able to provide petitions for redress, i.e. a petition of right. We're going to talk about that today, all right? A petition of right for redress, for remedies on behalf of the English subjects here and now, what we call North America, which the Supreme Court recognized that these remedies and relief under petition of rights are granted right, not a privilege. All right? You got to understand that. So these are the cases. Jefferson versus Booker. All right? Let's deal with that one. Jefferson versus Booker. This one was just filed with the district court in regards to a name correction from all capital letters to lowercase letters to associate myself with a natural person in lieu of my office as corporation sole. All right, which all documents were presented to the what we call probate court, because this act was filed in the probate court. All right. So I'm going to show you the minutes from this. As you can see, this was presented to the probate court. You see my name is not in all capital letters. All right. You see it right there. 6. This is my archbishop's recognition. I'm not going to show you that, though. That's personal. All right. His was recognized as archbishop in office of the English Third Temple Church. All right. This is the matter made to the Superior Court Law Division, probate, in regards to the matter of application to change it from the all cap to assume the name Clifford Jefferson in lower caps. All right. This is another attachment to the name in the matter in regards to the name application. They're assuming the new name, not the new name, but the true name. That was another attachment, Form C. We're going to keep scrolling up. It's a certificate, Form A1, certificate for name change. All right. To change it from all caps to lower caps. All right. Okay. Form A. 10. I request this name change for the following reasons. The name denotes to a legal person other than a natural person titled under 8 United States Code 1101A, Section 23. Petitioner is the English heir and declares allegiance to the England and Great Britain. The correction shows affiliation to the Third Temple English Church of England via religious customs. You see now authority, you see now certificate of incorporation, and it shows as corporation so it can only be assumed by a natural person, and natural person is different from a corporation. All right. And that was submitted before the probate judge in regards to the reason for the petition to have the name assumed to the lowercase denoting to a natural person and not a corporation in lieu of the all capital person, which is a legal person. All right. You see it right there. That was the verified complaint received May 30, 2023. Okay. 13, Middlesex County. Docket number 328723, civil action order dismissal. Under Title 15 United States Code, Section 7, they denote to a legal entity, as you can see here. I put it right there. That all cap is a legal entity. The judge's decision in the matter has been open to the court by it states in his order for dismissal of my application for a name change. Since the matter has been opened by the court by way of a verified complaint for the name change filed by petitioner Clifford Jefferson, pro se, to assume the name Clifford Jefferson. The court have considered the matter for good cause shown. It is ordered on the 21st day, June 2023, ordered that the above matter is hereby dismissed without prejudice for failing to meet the statutory requirements of New Jersey Court Rule 4:72 1-A, and it's further ordered that the copy of the order should be served upon all parties who have not been electronically served through the approved electronic court system pursuant to New Jersey Court Rule 1-322:A, nor served personally into the court. Honorable Christopher De Rafano, Chief Judge, whatever that stands for. All right. So as you can see, he denied the name to change it from all caps to lower cap as a result of contracts made with the all caps, right? Which it shows that there is another party or legal entity denoted to that, because I'm asking you just to change the name. I'm not running from no obligation. I'm just asking you to change the name from high caps to lower caps. Not even arguing about the contracts made under that, because nothing was made in his order in regards to the reason why he didn't allow the change in regard to whatever reason set forth. He just said meeting required under our statute, which is contrary to everything that was raised in the reason for the name change. All right, which automatically falls under what is called federal question. All right, diversity of jurisdiction. All right, diversity of jurisdiction. You claiming me to be a citizen of the state, and I'm not a citizen of the state. I'm a citizen of the church, i.e., a subject of the church. Why? Because I represent the church as corporation soul. So all this was already known that the court was going to do that. Why? Because the superior court is in violation of the law. Why? Because the Supreme Court is in violation of the law. Why? Because they're not recognizing they recognize the authority that the king has on his jury regalia, on his authority, on his prerogative writs. Because the petition was filed by way of a writ or order to show cause. I filed an order to show cause in this matter, but because of the the weight of the argument presented in order to show cause, no judge want to deal with this in the Superior Court as a result of what's going on in the District Court. All right, they don't want their hands on this. Why? I'm gonna show you the Supreme Court of New Jersey don't want their hands on this. Let me give you another example. All right. Let me go back here. That case right here, Christopher, is right here. Jefferson versus Christopher L. Herbert J. Rufino Christopher. That's the one who ruled in the name change. All right. That's the one. Where is that at? Sorry, right here. Well, let me go back here. I don't want to miss that point. Let me go back here. Okay. Christopher Rufino. That's his name. Honorable Christopher D. Rufino. So I know what they was going to do because they're the administrative court. They're not a constitutional court. So I already automatically know that I'm not going to get due process in that courtroom. I just wanted him to do this so I could remove it to the district court on based off diversity issues of citizenship. All right, which you see here in the stat on the docket. Right there. I don't let nothing slide. Okay. All right. Let's go here. This one is dealing with uh some matter dealing with a lawsuit I filed. This is the last lawsuit I filed in regards to retrieving property that belongs to the English church. And I think I got that too. I got that here too. Let me just show you this. All right. Jefferson versus Booker. I should have won that case, but the judge dismissed it. And look why he dismissed it. They're running from this truth, but they can't hide from it. We're dealing with Booker. All right. We're dealing with Jefferson or King Jefferson Booker. So let me go here. I think I got that here. No, I don't have that. All right, let me do this. All right, so we're going to deal with this one. Take you here. Bank of America. I'm suing the Bank of America. I'm not only suing Bank of America, I'm suing the Department of the federal government, Department of Treasury, as well as the United States. You see it right there. Chris Paul just shows you this one. This one is the city of New Brunswick for practicing slavery in regards to the birth certificate that they give you. This case was heard on the state appellate as well as Supreme Court, which is now in the district court. And like I said, I'm a pro se litigant, so I learn as I go along. And I just filed a writ of certiorari to the Supreme Court to review the Supreme Court, but I missed the time deadline, which is required by statute. It's unconstitutional, but that's fine because the matter was removed to the district court, which I had the opportunity to go to the circuit court for an appeal, then back to the Supreme Court, which ultimately is going to go back there anyhow. You know what I'm saying? So I got time. It's no problem. I can wait it out. You know what I'm saying? I know it's not going to be easy win. But I'm just to show you that they're running from me because this matter right here, Jefferson versus City of New Brunswick, as well as the state, as you see, it's City of New Brunswick and the State Department of Health. This matter is still open in the district court, as you can see here, filed April 3rd, 2023. All right. Let me show you my receipts. All right. If you hardly see me at uh this preliminary hearing, I was bad, boy. I was bad. But we know I'm going to show you that the state court, the appellate court, as well as the Supreme Court is unconstitutional as a result of the amending of the Constitution of 1947, right? And the governor at that time was Alfred Driscoll. All right, this is going to be probably a 3-hour lecture because of the ground I got to cover. All right, 1947, the Constitution of New Jersey was altered, which came from the 1844 Constitution, which was modeled, which the United States Constitution was modeled after, which both were preceded from the 1776 Constitution of New Jersey. All right, and we know that the Constitution of New Jersey invested the power of the King's Bench in the Supreme Court of New Jersey. All right, we're gonna hear this in case law. What's it called? Uh, what is it? Billen versus Harris. All right, we're gonna see that in Billen versus Harris. But this is an appeal to the appellate court of the state of New Jersey in regards to uh, them are labeling me as a corporate citizen. The same argument dealing with the name correction. The couples in the same argument. I filed a complaint, and the complaint was dismissed with prejudice. That gave me the opportunity to file it in the appellate court of New Jersey, and the appellate court dismissed it with prejudice as a result of the subject matter. All right. Nobody want to deal with this subject matter as a result the arguments that I'm bringing in lieu of what we call a prerogative writ, because we know in Ward versus Keening, it says that writ of circulator or writ of mandamus or writ of quorum is one of the best methods to bring forth and invoke the powers of the crown. I'm going to show you in case law. This is what I was doing, invoking the power of the crown as a result of me being in corporation sole, because I have that authority to do my certificate of incorporation, which now because of my charter, with the incorporated powers that we had through the corporation that existed going back to time immemorial, going back to that dates back to the Magna Carta. All right. It is verified in the complaint, which was raised in the appellate court of the Superior Court of New Jersey. You see the docket number. It is verified complaint before the Middlesex County Trial Court. The plaintiff is identified as the English Church of England member ETAL. The verification, however, makes it clear that Mr. Jefferson is the party pursuing the action. Mr. Jefferson also described himself as the plaintiff in the appeal of the docket. All right. Okay. Just a little summary of the argument raised in the state court and the appellate court. On May 22nd, 2020, after hearing oral arguments, the court in the first action entered an order to dismiss the complaint. Oh, actually, they dismissed it without prejudice. And they allowed me to amend the complaint, bringing a better argument, all right? Allowing the plaintiff to amend his complaint. Plaintiff filed an amended complaint on May 29, 2020. The amended complaint contained numerous allegations and passages explaining plaintiff's heritage and belief. In essence, plaintiff alleged that his birth certificate failed to include information about his ancestry, nationality, and religion, and sought to compel the defendant to issue a new birth certificate. Plaintiff sought money damages for alleged wrongs concerning the information in his original birth certificate, and defendant failed to correct his birth certificate. The defendant moved to dismiss the amended complaint for failure to state a claim upon which relief can be granted. After hearing oral arguments on October 16, 2020, the court in the first action entered an order to dismiss the complaint with prejudice. Plaintiff did not appeal for that order. The dismissal of the first action became final. On December 28, 2020, plaintiffs commenced this action by filing a verified complaint order to show cause. A second action, the verified complaint, plaintiffs identified as the English Church of England, members ETAL, by the verification makes clear that plaintiff is the party pursuing the action. Like the amended complaint in the first action, the complaint in the second action named department and city as defendants. The complaint in the second action also added as defendant registrar of the State Department of Health and Biostatistics. The complaint in the second action included many of the allegations plaintiff had pleaded, and the amended complaint in the first action. The complaint in the second action also sought the same relief sought in the first action, the amendment of the plaintiff's birth certificate and money damages. The defendant moved to dismiss complaint in the second action on January 5th, 2021. The court denied plaintiff's request for an order to show cause and dismissed the complaint in the second action with prejudice. Blase, blase, blase. They don't want to deal with the subject matter. They only deal with technicalities, all right? Because the only defense they can issue is that failure to state a claim. Why? Because they don't deal with the common law of England and administrative courts, and that's pursuant to the administrative courts that was established under the 1947 Constitution. We must understand why our cases are being dismissed. That left me with grounds to move for petition for certification. A petition for certification in the United States is actually synonymous with what we call prerogative, what we call a writ of certiorari. Once again, the petition for certification is no different than a writ of certiorari, which is the prerogative writ of the jure regalia of the king, which I'm personifying in these cases. All right. So, of course, I started as petition for certification, but I also issue a call warrant writ of mandamus to the Supreme Court to demand the appellate court and the state court to show just cause why the court warrant and the writ of mandamus should not be issued on behalf of me, i.e. the petitioner, in lieu of the writs that I presented to the Supreme Court. Now let's see what the review of the Supreme Court is. Let's check this out. A loss is not always a loss, because when you lose a case, they're always teaching you. So that was the city versus me, the plaintiff versus the appellate, and the defendants as the respondents. Now let's go to the Supreme Court. Okay. Let me go here first. Listen to the madness, y'all. This was the original complaint. English Church of England, State of New Jersey, City of Biostatistics, ordered to show cause. As I said, it was denied. The matter being brought before the court by Corporation So. Dismissed for no reason. Right? Dismissed for no reason. Why? Because they cannot deal with this. I'm going to show you. They cannot deal with this as a result of their constitution. Let's prove it. Because that was what was it called? What they say it was? An order to show cause. An order to show cause is a core warranto. A writ of core warranto is an order to show cause. They call it order to show cause. I call it a writ of core warranto. All right? As you can see here, here's the case summary sheet. All right. The case summary sheet. Everybody take a good look at this. Who want to be the one sitting in the seat when this argument comes before them? They got the plaintiff styled as a public entity. A public entity is a sovereign entity. All right. This was put on the case sheet, case docket sheet. All right. The city and state of health department, a business. Biostatistics, a business. Party description, state of New Jersey. All right. State of New Jersey. They didn't let it go no farther. Why? Let me show you why. All right. Once I had the give me a second, let me warm my coffee up because this is going to be a headbanger. Okay. Everything I'm showing you right now is being raised in the district court because we know district courts deals with federal questioning, diversity, violation under rights under color law, color statute, etc. So all these issues had to be raised in district court as a result of the unconstitutionality of the state courts from the Supreme Court on down, from the appellate court to the state court, because the state courts are courts of general jurisdiction. And we're specifically talking about New Jersey. All right. So I went, and this is the only matter we're talking about now is Department of Health and Biostatistics. All right. Because we know before our children were registered with the state, they were registered in the church. All right. So this case made it from the state appellate to the Supreme Court with a petition for certification. All right. I didn't start as a petition certification. Yes, I did. I started a petition certification, but the language is in lieu of what we call writ of circulator. All right. Because the petition certification is a writ of circulator. All right. After that was filed, I issued another letter to the court in regards to moving prerogative mandamus and core warrantum, all right, to the Supreme Court. Now check this out. I love how I teach. I love how my ancestors teach me. They save the best for last. Just when you think you made a mistake, it comes to fruition that there are no mistakes when you're learning. It's trial and error. So as I learn through trial and error, I get better. And in lieu of me pursuing the matter, the best is saved for last because I get it as a result of the inquiry that I made from the previous endeavor. You know what I'm saying? So it's very important to stay diligent to your study. All right? That's where the clarity comes in. So this is Supreme Court of New Jersey, the highest court in the land before the United States Supreme Court, or the district courts for that matter, because they all come into existence by the Judiciary Act of 1789. All right. They were not in existence when the Supreme Court of New Jersey was created, because the Supreme Court was created by the 1776 Constitution, and that was called a Court of Errors and the Court of Appeals. All right. We're going to visit Edward E. Keesby, a district court judge, who's going to tell you that as well. All right. Y'all better understand what's going on. It says, Dear Mr. Jefferson, this office, let me make sure you see that. Read it slow, y'all. Dear Mr. Jefferson, office in receipt of your papers dated November 27th, 2022, and captioned, Prerogative writ of mandamus quo warranto. Please be advised that your papers cannot be processed by the consideration by the Supreme Court. I wonder why. Now, in the prerogative writ, I'm telling the Supreme Court that you got authority to issue these prerogative writs, and I showed them in the prerogative writ mandamus quo warranto that you superseded your authority. All right, and as a result of them reading that, this is their response. Supreme Court does not exercise original jurisdiction over applications. That's not what the United States Supreme Court said. I mean, that's not what the district court said. Supreme Court does not exercise original jurisdiction over applications for prerogative writs. Prerogative writs, which include writs of mandamus, were superseded by an amending of the statute, Article 6, Section 5, Paragraph 4 of the New Jersey Constitution of 1947. So they forgot 1844 Constitution and the 1776 Constitution, which were all adopted the common law of England, which dealt with the prerogative which were invested in the Supreme Court. We're going to hear case laws to support that. The appropriate procedure now for seeking relief as a result of me bringing this shit to light, excuse me, my friend, bringing this stuff to light, you know what I'm saying? Because if they rule in my favor based off the prerogative authority I have as the king, that means that cat's out the bag. They can let that happen. They say, if you're going to go to the length, you're going to go the whole distance, Mr. King Jefferson. You're going to go the whole distance because I'm not going to be the one to be sitting in this seat when you come for yours. Supreme Court does not exercise original jurisdiction over applications for prerogative writs. Prerogative writs, which include writs of mandamus, were superseded by Article 6, Section 4, Paragraph 4. Section 5, Paragraph 4 of the New Jersey Constitution of 1947. The appropriate procedure now for seeking relief that was formerly available by prerogative writs is the following action in lieu of prerogative writs, which the Superior Court laws of which are pursuant to New Jersey Court Rule 469-1. All right? So that's what I did, because now you're telling me, Supreme Court, that you no longer deal with that as a result of the 1947 amended Constitution that was done by Alfred Driscoll and Rutgers University's gymnasium, which was property of the Crown, I might add. All right? But they said, please be advised that your notice of petition for certification and supporting documents have been filed, and your case is pending for consideration by the Supreme Court. At this time, nothing further is required of you. So, of course, they're going to dismiss the petition for certification because that's a writ as well. Let's call it writ of circulator. So as a result of me bringing this argument in this letter for quo warranto and writ of mandamus in regards to the writ I already got, known as the writ of circulator, called a petition for certification, the only thing they can do is dismiss that for no reason. Why? Because the cat is out the bag. They blame the Superior Court. It's out of our hands now. The Constitution says now the authority is in the Superior Court. The Superior Court didn't have the authority to do that because the legislature was powerless to sever that authority of the Supreme Court. That was embedded with the power of the King's bench that deals with prerogative writs. You don't believe me? Just look at it. Make sure I covered everything. Billin versus Harris. We talked about this case already. If those who've been listening to what's been said thus far, you have no problem following along. Those who didn't, I suggest you just forget it. You know what I'm saying? You just forget it. It's only for those who have the mentality to travel back, because what I'm doing is I'm broadening your perspective of understanding of the diagnosis that has been diagnosed by those who claim to be doctors in this stuff. They don't have a clue what's going on. Why? Because the Administrative Codes of 1947 only deal with administrative issues for administrative agencies by way of, as a result of the amending of the legislation. And we know in the 61-28 concerning property of the Crown, it was impossible to sever because it said this statute cannot be repealed. It cannot be repealed. Let's read it and weep. The evidence consists of records of proceedings before the administrative agency. That's the Supreme Court on down. All right? This one case, Villain versus Harris. All right? And this was by Chief Justice Vanderbilt. Was this Vanderbilt? No. Vanderbilt was in War versus Keenan. All right. But this is Chief Justice Vanderbilt in regards to the petition for certification, or what we call a writ of certiorari. You hear that? The provisions of the statute taken together with the accumulated decisions law make the action essentially the same in nature and scope as the common law writ of certiorari, a prerogative writ. You hear that? Everything I presented to the state, the appellate court, the Supreme Court was a prerogative writ, but the Supreme Court said they ain't got the authority to deal with no more. The only way you can deal with that is to go according to rule, statutory rule, New Jersey's statutory rule 469-1, which now became statutory law, which took authority from the Supreme Court to the Superior Court, which is the regional court I'm appealing from. So that means that the appellate court don't have no authority to even reveal a writ of certiorari, nor the Supreme Court, because they don't deal with prerogative writs, such as a writ of certiorari. All right? Because we just read here in Villain versus Harris that a writ of certiorari is a prerogative writ. And this case was in 1980. Did y'all hear me? 1980. This is how you bring the heat. The action as well, and this is why these cases are sitting in the docket right now in this court, because of this heat. The action as well as the rule of decisions is closely analogous to those governing that prerogative writ. The evidence consists of the records of proceedings before an administrative agency, because a writ of certiorari means to present the whole record from the lower court to the higher court, all right, to be revealed. That's what a writ of certiorari petition for certification. The evidence consists of the record of proceedings before the administrative agency. The rule of decisions on review of that record is whether it contains substantial evidence to support the agency's decisions in most cases. In some cases, the review may include the questions whether the agency's decisions correctly applied governing law, including rules and regulations, and others may bring into question the meaning and interpretations of that law, or its validity or the constitutionality of one provision or another, or other procedures employed. Did y'all hear me? This is the argument I'm raising in the district court. If the district court dismisses it, I'm going right to the appellate court, i.e. a circuit court. And the circuit court, if they, because it's going to have to go to Supreme Court, because I wouldn't want to be a judge sitting here in this matter. And Supreme Court ain't going to be able to do nothing about, because Supreme Court had that authority according to this case, which is raised in all my petitions to the district court. All right? And the district court is a federal court, I might add. Check it out. Let's continue. Since the federal courts are not courts of general jurisdiction possessing all powers of the King's bench, the accumulation of precedents in general fields is somewhat nebulous, especially since the law in each of the circuits is controlled by decisions of the courts of appeals, i.e. circuit court, and that particular circuit, until sometime as a decision of the Supreme Court of the United States resolves difference between those circuit courts, which is going to be the case in this case. Why? Because Supreme Court ain't got no authority outside of the Supreme Court of New Jersey, because they're not courts of general jurisdiction. They're courts of review. All right? The state of New Jersey, whose boundaries coincide with those of the district court, is one of the original 13 states of the Union and is a common law state. The structure of its laws may be looked to for the general background about prerogative writs in general and the writ of certiorari in particular, i.e. my petition to the Supreme Court of New Jersey. All right? They say they ain't got the authority to do so. Why? Because of the amendment of the Constitution of 1947. You read it for yourself. All right? I'm telling them they lying. And because I told them they were lying, that's the only thing they could come on. They couldn't say, you right, Mr. Jefferson, King Jefferson, you right. They can only stick to that script. Why? Because they was obligated to do so by those who put them in office. All right? It says right here in Villain versus Harris, The New Jersey's first constitution, adopted July 2nd, 1776, terminated its status as an English colony, it didn't say state, and began its sovereign existence as a state. Essential, because we know the states were countries, all right? They were colonies representing different nations who colonized North America, all right? Article 22 of the Constitution continues the common law of England for whoever was sitting in that colony at that particular time in those settlements, all right? Because they were English settlements. They were just under the authority of the British monarchs who were governing the British, Scottish, and the Irish throne, all right? It's simple. All right, the Constitution of 1844, let me read this again because this is very important. The New Jersey First Constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. All those judges who are sitting in the district court with these complaints, you better be watching this video. All right? Whether you know it or not, I'm sharpening my skill. I'm sharpening my sword. The same thing you see here is the same argument I'm raising in these courts. All right? The New Jersey Constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. I'm gonna be like what they call Roman Este Esquire. I'm gonna be in the white people's court demonstrating this. Who want to be arguing with me? What attorney general want to be sitting there arguing with me? Because I'm going right to Article 22 of the 1776 Constitution, which states that it continued the common law of England, which is still in force. That constitution was replaced by the Constitution of 1844, modeled largely in structure and content on the Constitution of the United States. This is a 1980 case, y'all. A 1980 case. By Article 10, Paragraph 1, it too continued the force of the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947. By Article 11, Section 1, Paragraph D, continue the force of existing law. So what the hell is the Supreme Court talking about and their denial of my petition for certification, as well as my writ of quo warrant on writ of mandamus that was presented to them, as you see, bear as evidence on the record? They know what's coming. They know what's coming. Why? Let's read further. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, as modeled from the 1947 Constitution, 1844 Constitution, which is modeled after the Constitution of the United States of 1789. All right? Of 1789, you just read it in the paragraph above. It said, it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the power of the King's Bench. So when I went to my King's Bench to issue the prerogative writ on behalf of me, the King's Bench, on behalf of the subject, me, because the king can't be sued in his own court. All right? He can't be sued in his own court. See Chisholm versus Georgia, see United States versus Keefe, which we're going to go to in a second. All right? It was a long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which the legislator was powerless to cut down or to assign to other courts. You hear that? So how did the power of the Supreme Court and the prerogative writs that were assigned to the Supreme Court by the Constitution of 1844 and 1776, going back to the common law, going back to time immemorial, how was it assigned to the Superior Court by the Constitution of 1947? Because this case reads contradictory to that. It says this principle was especially strong in the field of prerogative writs, of which the writ of certiorari, i.e. petition for certification, was the most frequently sought. Did y'all hear that? Did y'all hear that? The complexities and technicalities involved in the prerogative writs include certiorari, induced the draftsman of the 1947 Constitution to raise procedural necessities while preserving the judicial authority and the remedies. This was achieved by a single sentence. Prerogative writs are superseded, in lieu thereof, review, hearing, and relief shall be afforded in the Superior Court on terms and in the manner provided by the rule of the Supreme Court as a right, except in criminal cases, which review shall be discretionary. Did you hear that? They disqualified. This case is their doom. This case is their doom. They erase the procedural necessities while preserving the judicial authority of remedies under the administrative agencies, which was called into question with this case that was brought to who? The district court in 1980 in New Jersey. So this is why these cases are sitting stuck in limbo, because this case was raised. Yes, these cases, I could bring the smoke. I'm bringing that smoke. You hear that? 1, 2, 3, 4, 5, 6, 7. 7 active cases in the district court, all based upon Villain versus Harris. All right? Villain versus Harris. District court. All right? Let's move further. Okay. Let's go here. Edwin Quentin Queensby. I don't think you can see this book. No, you can't see it. All right. Everybody, I'm going to show you the book. A district court judge. This who speaks for me. The spirit of the dead. Anthony Quentin Queensby, 1824, was an American lawyer who served as United States Attorney for the District Court of New Jersey under 7 presidents. Did y'all hear that? In addition, he authored a book or poetry called From the Hudson to St. John and Home Flower, pressed in my law book. He was also a part of the writing of the marching song of the First Arkansas. In addition, he wrote the law book called Slavery in New Jersey. Did you hear that? He served under Abraham Lincoln, Andrew Johnson, Ulysses S. Grant, Rutherford B. Hayes, James Garfield, Chester A. Arthur, and Grover Cleveland. All right? These are the sages who records the decisions in the depositories of the law, which should be rooted in the common law, as we see it in Villain versus Harris. All right? Let's see it in his commentaries. Edward Quentin Queensby. Everybody needs to study about him. Let's go to his commentary. The courts and lawyers of New Jersey from 1661 to 1912. All right? That's a book he wrote. Courts and Lawyers of New Jersey from 1661 to 1912. Okay? Supreme Court of New Jersey. You see Justice Parker, Justice Dixon, Justice Scudder, Justice Depew, Chief Justice Beasley, Justice Van Sickle, Justice Knapp, Justice Reed, and Justice Higgins. All right? These are the judges of the Supreme Court of New Jersey. Let's read a little bit about these judges in Supreme Court, New Jersey. All right. Villain versus Harris used that to reflect this case by Edward Quentin Queensby, a district court judge, because that case was a district court ruling in New Jersey. Okay. Yes, sir. This is how you bring that fight to them, y'all. Chapter 30, Supreme Court by Edward Quentin Keesby from 1661. This is the time of the monarch. We know New Jersey Provincial Council under New Jersey Province from 1644 to 1776 on the authority of the crown, because we know the proprietors surrendered their authority back to the crown in 1702 under Queen Anne. All right? So let's read a little bit about the history of the Supreme Court, because it's in question now. The authority of New Jersey Supreme Court is in question now. The Supreme, y'all see that? Somebody give me a thumb up. Give me some love. Show me some love. Post some comments. Say something. Let me know you appreciate this. All right. Hit me up on the Cash App. Do something. Show me, because it says a prophet get no honor in his own house. These are prophecies being revealed to you. All right, for your common good. All right, for your common good. The Supreme Court, Chapter 30. No definition of jurisdiction of the Supreme Court or of any of other courts is to be found in the Constitution of 1844. And we know the United States Constitution was modeled after the 1844 Constitution. And slight mention, of course, is made in the Constitution of 1776. It was an act of legislature of October 2nd, 1776. I.C. William Patterson. And we know William Patterson was the first, if I'm not mistaken, world governor, and he had William Franklin locked up, if I'm mistaken. Don't quote me on that. It's been a minute since I talked about that, but William Patterson was a governor of New Jersey. All right, don't quote me on that last statement. It states that it says October 2nd, 1776, that declared that the several courts of law and equity of the state should be confirmed and established to continue to be held with the like powers under the present government as they were held at and before the Declaration of Independence lately made by the Honorable Continental Congress. You hear that? We're talking about the Articles of Confederation. The Constitution of 1844 enumerated courts in which the judicial powers should be vested, and these included a Supreme Court, circuit courts, and such inferior courts now exist as may be hereafter ordained and established by law, with which inferior courts the legislature may alter or abolish at the public good may require. Constitution, Article 6, Section 2. The courts so enumerated were the courts existing at that time. The circuit court as a separate court, distinct from the Supreme Court trying cases at the circuit, had then recently been established by the statute of 1838. But the Supreme Court had existed since the ordinance of Law Cornbury, and there had been such as court under the proprietors. The ordinance of Law Cornbury and their later ordinances declared that there was to be held at Amboy and Burlington, alternatively, a Supreme Court of Judicature, fully empowered to have cognizance of all pleas, civil, criminal, and mixed as fully and amply to all intent and purposes whatsoever as the courts of the Queen's Bench, Common Pleas, and Exchequer, which Her Majesty's Kingdom of England have ought to have. It is to the history and jurisdiction of these courts, therefore, that we must look in order to determine what is the jurisdiction of the Supreme Court of New Jersey. Did you hear that? This is by the District Court, Quentin Keesby, Edward Quentin Keesby. He's telling you this. The examination has been made by our own courts, and the jurisdiction of the Supreme Court has been defined by its own decisions and those of the Court of Errors and Appeals, as I stated recently. It may be worthwhile, however, to refer briefly to the origin and growth of the power of these English courts, and to refer to the books in which one may seek the sources, as well as follow the streams of the jurisdiction of the courts of the common law. Did you hear that? Well, let's visit it. The ordinary Anglo-Saxon courts of public justice were the county courts of the 100 courts, because counties call hundreds. The business of the king was not to see justice done in the ordinary courts, but to exercise special reserved powers, which a man must not invoke unless he failed to get his cause heard in the jurisdiction of his own hundred, i.e. county. Under earlier Norman kings, there is the beginning of a career regis, which was succeeded by the Parliament of England. But it was the first in the main of courts only for great men and great causes, because we know the career regis was preceded by Wittemont, or what we call Witten. The local courts communal and signoral were the original tribunals for ordinary causes. The King Justice was still extraordinary, and even the pleas of the crown were for the most part heard by sheriffs and the sheriffs. Why you think when you go to a court, you always see a sheriff? Then again, the King's Court was not in permanent session. Under the two Williams, the name career regents seemed to be borne only by those assemblages that collected around the king thrice a year when he wears his crown on the great festival of the church. Under Henry II, something that is more like a permanent tribunal, a group of justiciars presided over by a chief justiciar becomes apparent. Twice a year, this group takes the name of exchequer, sat around the checkered table, received the royal revenue, and audited the sheriff's accounts and did incidental justice. From time to time, some of his members would be sent through the counties to hear the pleas of the crown. And the litigants, who were great men, began to find it worthwhile to bring their case before their powerful tribunal. Did you hear that? So they're going all the way back. Chief Justice Edward E. Queensby, in regards to the authority of the Supreme Court, which we've seen in the 1980 case versus Butler versus Harris, that the authority of Supreme Court in 1980 goes all the way back to the authority of the Supreme Court as established under the crown, going back to Henry II of the Kingdom of England and of France by way of the marriage of Matilda and Godfrey, who was Henry II's father. All right? So there you have commentaries by Edward E. Queensby, Edward Quentin Keesby, a district court judge, where these cases on behalf of crown subjects are being heard on the arguments that I'm raising in this lecture today. All right, so somebody please show me some love. Let's move forward. We know George Carteret, George Carteret and John Berkeley, or John Berkeley, George Carteret, whatever name they was, inherited territory which we call Channel Island. All right, Channel Islands were known as Jersey. All right, or Belwick of Jersey, and we know that New Jersey now, as a result of the profiteers, before it was surrendered to the crown under Queen Anne, they would consist of what we call East and West Jersey, all right, which was larger than what it seems today, which we're going to hear a case to support that, Ward versus Keenan, all right, and not Ward versus Keenan, Martin versus Waddell, all right, but we must understand the alliances and the treaties that were made as a result of those alliances and the impact they have today on the common people and the uncommon people in regards to those who were really classified as subjects here on this particular landmass, because these were the king's overseas territories, all right, under his radical title. Let's go back and let's travel back in time, y'all. Going back to the early days of the colonies of New Jersey, you got to go back to the Treaty of Westminster of 1674, which involved the Third Anglo-Dutch War. All right, we talked about this yesterday. So to get a clear precept of what was talked about, please review the last lecture I did. As you see, the Statute of Westminster of 1674 ended the Third Anglo-Dutch War between the Swedes, the Dutch, and the Netherlands, which is called New Netherlands and New Sweden. All right, and that took the accounts for three wars called the First Anglo-Dutch War, the Second Anglo-Dutch War, then the Third Anglo-Dutch War, which resulted with the restoration of Charles II, and the Third Anglo-Dutch War, which was filtered down from the First Anglo-Dutch War, which involves Oliver Cromwell, and that goes back into where Channel Island was under the authority of the Stuart monarchs to what we call the English Civil War, or what we call the War of the Three Kingdoms. I don't want to go through that for the sake of time as a result of longevity, but please understand that history, all right? we know that the Treaty of Westminster from 1654 to the Treaty of Westminster of 1674, 1654 to 1674 involved the Anglo-Dutch War, which involved the territory known as Channel Island, because we know that Charles II was crowned in Saint Mount, what they call the island of Saint Helier, and Saint Helier is where what they call the what they call what's it called the Jersey Battle or the Battle of Jersey. All right, 1778, sometime around there. It was called the Battle of Jersey. That's situated in Saint Helier, which the United States were a part of. Okay, Battle of Jersey. Well, we know before they had the Battle of Jersey, you had the Treaty of Westminster and the Treaty of Westminster of 1654 and 1674, which ended the conflict between the Swedes, the Dutch on New Sweden and New Netherlands. And then prior to that, you know that they go back to the authority of the grants and deeds that were made by the monarchs that preceded them, i.e. Charles I, going back to James I, all right? And you know, James I, through the Union of the Crown, got their allegiance with the treaties they made with the kingdom of what we call the Kingdom of England, due to de facto monarchs under the authority of what we call Henry VIII. Henry VIII was from the House of Tudors at the time of what we call the War of the Roses in the 100-Year Wars, because he came from the house of what we call Lancasters. All right, there were two branches, the York and the Lancaster branches were cadet branches of Plantagenet crown. All right, so when you're dealing with the treaties of Westminster of 1511 and Treaty of Westminster of 1527, they encompasses two treaties of perpetual peace of 1503 and 1534, which were treaties made with the kings of Scotland, King James V, King James VI, with Henry VII and Henry VIII, which were both part of the House of Tudors, because Henry VII established the House of Tudors. All right. I don't believe I'm spitting it like this. All right. So instead of going through visit the treaties of Westminster of 1511 and Treaty of Westminster of 1527, which involved the Scottish and the English kings under the authority of de facto authority as a result of the wars between the War of the Roses, which was the cadet branches of the Plantagenet cadets, where they inherited the Duchess of Normandy by way of the marriage between Godfrey and Matilda, known as the Treaty of Westminster of 1153, which resulted in the conflict between Matilda and Stefan, known as the House of Blois, when after Stephan's reign that the crown would go to Godfrey's son, Henry II. And Henry II was the father of John, Richard, and Henry III, which Edward I was descended down from, which resulted in what we call the conflict going back to the Scottish Wars and to Scottish independence in 1295, as well as the Ordinance of Alliance of 1295, which resulted in alliances made with the Frankish kings and queens that descended down from the what we call the descended from present day Francis I, which is descended from the Valios Aquilamain houses, which was descended from the House of Capet, from the House of Capetan dynasty, who's born with the Plantagenet through the Capetan Plantagenet War, which results in the Treaty of 1259. Okay, and the Treaty of 1259 it succeeds the Treaty of Westminster of 1153 when Henry II comes to the throne of the Duchess of Westminster, and which was connected to Channel Island, which New Jersey is founded from. All right. Hope that didn't confuse you. If it did, please review the last lecture I did prior to this one. All right, let's move forward. So we know the Treaty of Westminster of 1511 and the Treaty of Westminster of 1527 all involve treaties under the Kingdom of England. All right, because we know the Treaty of Westminster was made with the government of Westminster. That was the government of England. All right, under the Parliament of England. Prior to that, called the Career Regis, and prior to that, called Wittemont or Witten. All right. So under the Henry VIII and Henry VII from the House of Tudors, from the Lancaster branch, that brings us to the Treaty of what we call the Treaty of Perpetual Peace of 1253. Let's review that. Treaty of Perpetual Peace was signed in 1534 between James V of Scotland and Henry VIII of England from the House of Tudors. All right. Very simple. Treaty of Perpetual Peace of 1503. Well after, and well before the treaties of Westminster of 1511 and 1527. All right. Treaty of Perpetual Peace was a treaty of perpetual peace signed with James IV of Scotland and Henry VII of England, the founder of the House of Tudors, in 1502, which brought forth the Union of the Crown in 1503. All right. It is agreed to end the intermittent warfare between Scotland and England, which had been waged over the previous 200 years, and although it fell in this respect, as hostilities continued intermittently throughout the 16th century and led to what we call the Union of the Crowns. The Union of the Crown and the consequences of the Union of the Crown was a result of an artist alliance. Was the result of an artist alliance that Scotland made with France prior to Henry VII and Henry VIII. All right, because Henry VII conquered England and then went on the discovery of the territories that was subject to England by way of the territories colonized here in North America by Francis I in 1492 through the age of discovery, knowing that the ancestors of the Plantagenets in the Crown were already here that were now misnominated as what they call Native Americans. And the Native Americans, as I'm going to prove, didn't have the right to the land because they were only considered mere occupants of the land. All right? Let's get to this nitty-gritty. Consequences of the Treaty of Perpetual Peace of 1503. It says the treaty was broken in 1513 when James declared war on England. King James the Sixth, apart himself, the Fifth, because the Treaty of Perpetual Peace of 1503 was made with King James V. The Treaty of Perpetual Peace of 1534 was made with King James the Sixth. Yeah. Let me just review it again. No, part itself. Yeah, part itself. The Treaty of Perpetual Peace was made with King James V. All right, in 1534, and then the Treaty of Perpetual Peace of 1503 was made with King James IV, from the same houses of the House of Stuart. All right. The consequences of the Treaty of Paris of 1503 made with King James IV, the treaty was broken in 1530 when James declared war on England in support of the French, who had lately been attacked by English. All right. So now France is at war with the House of Tudors. All right. This is why the House of Stuarts took side of the Frankish kings as a result of what we call the Old Alliances, which were alliances made with not just France, not with just Britain, not with just English, but as well as not English in the true sense of the word, but the British king sitting on English, but as well as with the American through the Treaty of Alliance of 1778. We're going to show you. So it said that the French was at war with English, and James was acting according to Scotland's obligations to France under an older medieval defense called the Treaty of Alliance. All right. So the House of Stuart or the Kings of Scotland was subject to other alliances that were made with France prior to the Treaty of Perpetual Peace in 1503 and 1534, which brought forth the Union of the Crowns, as well as the treaties of Union of 1707, as well as the Union what's called Unification of Great Britain, called the United Kingdom of Great Britain. All that is de facto. It's all de facto. Why? Because let's go back to Scottish independence. I hope you all taking notes, because you're going to be questioned on this if you come into the English Third Temple Church of England. You're going to have to know this before you make entrance to my father's house. Scottish independence is an idea of Scotland as a sovereign state, independent from the United Kingdom, refers to the political movement that is campaigning to bring it about. Scotland was an independent kingdom through the Middle Ages and fought wars to maintain its independence from England. All right. The two kingdoms were united in personal union in the year 1603, right after the union of the crowns, when the Scottish King James VI became James I of England, and the two kingdoms unity politically into one kingdom called Great Britain in 1707. The movement united the countries which ended the War of Independence and created a peace of tranquility for who? For them, not the English people, because they took away the English rights. All right? Let's go to the history concerning this. Kingdom of Scotland. Scotland emerged as an independent polity during the early Middle Ages, with some history historians dating its foundation from the reign of Kenneth MacAlpine in 843. The level of independence of the Scottish kingdom was fought over the Scottish kings and by the Norman and Angevin rulers of England who petitioned the Pope and other foreign rulers. So the Norman and Angevin rulers are those who were under the rulership of Godfrey and William the Conqueror, because William the Conqueror invaded Normandy, which at that time was under the rulership of the Plantagenet and Angevin crown, going back to the Angler houses under what we call the Folks. All right? The Robertians are not descendants of the Folks because they descended from the Carolingians, which were the Merovingians, which gave birth to the Capitan, House of Capet, i.e. the Acclamane, and House of Velios, which Edward I descended down from. All right? It says that a watershed in Scottish kingdom history was a succession crisis that erupted in 1290 when King Edward, the son of Henry III of England, claimed rights of appointment to the Scottish throne. The old alliance of Scotland and France against English interests was first invoked at the time and remained active through the 16th century, and is still active now. The wars of Scottish independence ended with the renewed kingdom of Robert the Bruce, whose grandson Robert II of Scotland was the first Scottish king of the House of Stuart, who now gave out deeds when they came over to colonize North America, and it's based off the settlements that they created. Prior to that, there already was settlements of English, i.e. true English descendants going back to the Plantagenet crown through the Duchess of Normandy. And we know the Duchess of Normandy goes back to those who descended down from Henry II. All right? Because we know Louis VII, Edward I, who colonized North America under called the New World, was under the authority of the Frankish kings who were warned with the Plantagenet crown. So that would only make sense to know that the Plantagenet crown were over here. Because my grandfather, Leotis Jefferson, i.e. Leotis Godfrey, bears the surname Godfrey, i.e. Jefferson, but he looks like a Native American with facial characteristics that denote to what we call a mutation or a mitosis of the genetics. All right, which results into what we call me, which we have today. All right, let's get to it. From 1603, Scotland and England shared the same monarch in personal union with James VI of Scotland, and was declared the King of England and Scotland in what was known as the Union of the Crowns in 1503. Well after the Treaty of Paris, Treaty of Perpetual Peace of 1503, and 15 parts of. Union of the Crowns of 1503, and then that brought birth to what we call the Treaty of Perpetual Peace of 1502, 1503, 1503 and 34. All right. Lots of stuff to remember, y'all. So let's get on to it. Scottish independence came with the war between Edward I, and Edward I was of the Plantagenet crown. All right. So as a result of the war, what the Scottish kings had with the Plantagenet crown, it only made sense for them to align themselves what we call the Frankish alliance, because they were at war with their English kings as well. And English kings were French kings through the marriage of Matilda of Scotland to Henry I, son of William the Conqueror, who invaded Normandy. Because we know Matilda of Scotland descended now, because she was the grandmother of Edward the Confessor, son of Ethelred and Ready, the son of Jesus Christ. All right. These are facts. All right. So the Old Alliance. What is the Old Alliance, which preceded the Treaty of what we call Scotland independence of 1296? This is the Old Alliance. Old Alliance was made with Scotland in 1295. Scotland independence didn't come until 1296, and in 1296 they were warned with who? English. All right, they were warned with the English and the Plantagenet and the Angevin crown, because the Angevin crown was established by John. All right. This is the 100-Year War. You had two of them, the first 100-Year War and the second 100-Year War. So the audience of alliance was alliances between the Kingdom of Scotland and France against England, made in 1295. You hear that? 1295. These are all the alliances made even before 1295, made with the opposite dynasty, the Mongoloids, the Scottish, the Polish, the Hungarians, the Ottoman Turks, the English, not us, the Anglo-Saxon English, but those who were ruling under the English Empire under the House of Stuarts at that particular time. All right? The Anglo-Dutch Wars. That started in 1654 to 1674. Then the Franco-Indian Alliance, Franco-British Alliance, Franco-Spanish Alliance, Franco-Prussian Alliance, Franco-Austrian Alliance, Franco-Indian Alliance, Franco-Vietnamese War Alliance, Vietnamese Alliance. That goes to the Vietnamese War. All right? Franco-American Alliance. All right? That gets into what we call the Battle of Jersey, 1778 to 1794. Franco-Persian Alliance, Franco-Prussian Alliance, Franco-Austrian Alliance, Russian Alliance, Entente Cordiale, Franco-Polish Alliance, Italian Alliance, Franco-Soviet Alliance, the Western Union North Atlantic Alliance, the Western European Alliance, European Defense Alliance, then all the other regional relations that are existing to this present day. All right? The alliances played an important role in the wars of the Scottish independence, the 100-Year War, the War of the League of Cambrai, and the Royal War. The League of Cambrai was one of the wars of the Treaty of Westminster 1257, if I'm not mistaken. Let's revisit that. 1227, right here, Treaty of Westminster. That involved Francis I and Henry VII. Let's move forward with this lesson. I'm just hit and miss with these case laws because I want to bring this close to an end. All right, let's go here. War versus kingdom, the power of a natural person as a private citizen in regards to filing a petition or writ of circulator. Just like we've seen in Felon versus Harris. All right, let's go back here. Felon versus Harris. Common law, writ of circulator. As a prerogative writ, you should be able to raise that in the Supreme Court in lieu of a court of review under the English common law as set forth in Felon versus Harris and the 1980 case that the Supreme Court is upholding. I mean, the district court is upholding. All right? You see it right there. And the legislator and the other courts is powerless to say anything. This is why the Supreme Court has bowed down. Look, we're sorry. It was the legislators who did this. It wasn't us. We only going by what the legislators say. All right. And the legislator is held by their constitution, but we see case law reflecting all these constitutions, which the United States Constitution is largely modeled after, pursuant to those facts concerned with the common law and the power of the King's Bench, and the head of the King's Bench is his chancellors or counselors. All right. And they all have what we call a petitioner right under redress to the king. How we know that? Let's see. We see here in War versus Keenan. All right, this is Superior Court, New Jersey. Let me show you. Appellate Court, Superior Court. Chief Judge Vanderbilt. All right. He was the first Chief Justice under the 1947 Constitution. All right. That's now an administrative agencies with administrative courts. And this is what he says in regards to the prerogative such as the writ of circulator. Just anyone can do this. Only a private citizen. The person in this complaint who filed the prerogative writ got it granted, but when it came up for review to the Supreme Court, the Supreme Court had to check their subject. All right, you can't place both sides in this field. You can't serve two masters. And Supreme Court checked him. He was letting them know, look, even though you took leave from your job at the police department to run as a county commissioner, to expose as a whistleblower the corruption inside the police department, you still got to follow the administrative procedures in regards to the due process of law that you're going to receive. And that does not pertain to a writ of circulator, which is only reserved for private citizens under the Crown. Because it says here, the special significance in the broad scope of the writ of circulator in New Jersey in protecting an aggrieved citizen from almost every form of improper official action is epitomized by Holdsworth in speaking of the prerogative in generally. The judicial control could be applied at a suit of the private citizen. The private citizen could set forth a motion, the different forms and procedures open to the Crown. In addition, he could bring a civil action. This power to bring civil action was in effective control of safeguards of the liberties of a subject and one of the best of all securities for the maintenance of supremacy of the law. They're talking about a corporation soul. All right? And private individuals incorporating under the laws of the Crown to protect Crown property that's intel. All right? Crown property that's intel is inheritable to heirs. It doesn't estate to the state or the corporation known as the state because that's what they're called. All right? Supreme Court has made their ruling on that. Let's prove it. United States versus O'Keefe, 1870 case. All right. Everybody pull that case up. Wrap your head around that. Now, keep in mind that the United States Constitution was largely modeled after the 1844 Constitution of New Jersey as revealed in Billing versus Harris, right? We see that. And that was case in the district court. Now we're reading about the United States Supreme Court, all right? In regards to sovereign ability to petition for relief to the king or the crown, all right? And this case deals with the power of the state or the state corporations to claim immunity from suits, which they cannot claim immunity for suits. All right, I'm gonna show you two cases that deal with that. Everybody take a 2-minute break. 2 minutes is up. You know, it amazes me that people, you know, shy away from my channel because they're forced to answer questions that they don't want to deal with. And the most common question that they don't want to deal with is the question of rights. What? Who says you have rights? Can you prove that you have rights here as a citizen on the state and federal level? Can you actually prove that? No one has took it upon themselves to actually prove that. They're assuming that they have rights and hoping that some rights that they so-called have will at one day come to their rescue. But none has proven it by the lack of exercising that rescue of as provided by the law, i.e., due process of law. No one has proven it. That's sad. It's very sad. Somebody give me a response to that question. What you think about that question? United States versus O'Keefe. Supreme Court. All right. Supreme Court of the United States. And they know that the Constitution of the United States was largely modeled after the 1844 Constitution of New Jersey. So when they're talking about United States, they're talking about New Jersey. They're talking about United States, they're talking about New Jersey, and they're talking about the Crown. All right? In England, it is easy to see that the method of redressing injuries to which the Crown is a party would be different from the remedies adopted in this country in case the United States be the aggressor, because of the principles underlying the English Constitution, that the king can do no wrong. On this account, although it would not do the on this account, although it was not due to issue mandatory processes against the sovereign, yet the law being unwillingly that private rights should be invaded in the conduct of public affairs and not redressed, has furnished the subject who is thus injured with a mode of obtaining redress, which is consistent with the idea of kingly prerogative. The law allows him by petition to inform the king of the nature of his grievance, and as the law presumes that to know of an injury and to redress it are inseparable, and the royal breast is then issued as of course in the king's own name. His orders to his judges to do justice to the party agree, as you can see, as demonstrated in the Supreme Court petition. They recognize that I know who my courts are. You're my courts. And now that I'm exposing you, you don't want to bow down to the king as a result of you know what's going to happen. Because all kings, all judges take an allegiance. That's treason. That's a felony. The valuable privileges secured to the subject in the time of Edward I is now crystallized in the common law of England, as the prayer of the petition is grantable ex debito justice. It is called a petition of right and is a judicial proceeding to be tried like suits between subject and subject, and it does not exist by virtue of any statute, nor does the recent legislation in England concerning it do more than to regulate the manner of its exercise and to confer on the petitioner the privilege, not before granted, of instituting his proceedings in any one of the superior courts of common law of equity of Westminster, i.e., treaties of Westminster. They were all governed under the crown. They're using Edward I and the United States Supreme Court, which was of the Plantagenet crown. The authority of the Plantagenet crown is still here. Let's find another source. Chisholm versus Georgia. Supreme Court as well. The power of the general government, we know that the United States is the central government, a weak government. The power of the general government, either of the legislative or executive nature, which particularly concerns treaties with foreign powers, do for the most part, if not wholly, affect individuals and not states. You should hear that. They require no aid from any statutory state authority. This is the great leading distinction between old Articles of Confederation and the present Constitution. The judicial power is of a peculiar kind. It indeed, one second. It indeed commemorates with the ordinary legislative and executive powers of general government and the powers which concerns treaties. But it also goes further. Where certain parties are concerned, although the subject in controversy does not relate to any of special objects of authority of the general government, wherein the separate sovereignties of the state are blended in one common mass of supremacy. Yet the general government has judicial authority in regard to such subject of controversy, and the legislature of the United States may pass all laws necessary to give such judicial authority and proper authority for himself. Authority is proper effect. We move a little further. Right here. If therefore no remedy be provided as plainly in this case, and consequently we have no other rule to govern us by the principles of the pre-existing laws, which must remain in force till superseded by others, then it is incumbent upon us to inquire whether, previous to the adoption of the Constitution, which periods of passing laws in respect to the object of this inquiry is perfectly equal. And actions of the nature like this before the court could have been maintained against one of the states in the Union upon the principles of the common law, which I have shown to be alone applicable. If it could, I think it's now maintainable here. If I could not, I think as the law stands at present, it is not maintainable, whatever opinion may be entertained upon the construction of the Constitution as to the power of Congress is to authorize such one. Now, I presume it will not be denied that in every state in the Union, previous to the adoption of the Constitution. The only common law principle in regards to suits that which in manner admissible in respect to claims against the states were those which in England apply to claims against the crown. There being certainly no other principles of the common law which previous to the adoption of this Constitution could, in any manner or upon any color, apply to the case of the claim against the state in his own courts, where it was solely and completely sovereign in respect to such cases at least. Whether that remedy was strictly applicable or not, still I apprehend there was no other. The only remedy in a case like that before the court by which by any possibility a suit can be maintained against the crown of England or could be at any period from which the common law as enforced in America can be derived, I believe is that which is called a petitioner right. It is stated indeed in Commons Dig 105 that until the time of Edward I, the king might have been sued in all actions as a common person, and some authorities are cited for that position, though it is even there stated as a doubt. But the same authority added, but now none could have an action against the king, but one should be put to suit to him by petition. You should hear that? One second. Let me read that again. Let me go back. All right, this is Chisholm versus Georgia, 1793 case. For those who didn't see what I had displayed, part itself on my behalf. All right, let's just retract a little bit. All right, Chisholm versus Georgia. We already know in the United States versus Keefe that it said that the The way for remedy in lieu of redress was the petitioner right sought back in the times of Edward I. Now we're reading here in Chisholm versus Georgia in 1793, the same remarks by the same United States courts in 1793. All right? In 1793, a couple of years before, a couple of years right after the adoption of their Constitution. All right? After a couple of years after the adoption of their Constitution, in the state, if therefore no new remedy be provided, as plainly in this case, as consequently we have no other rule to govern us but the principles of pre-existing laws, which must remain in force till superseded. Let me make sure you said, yeah, till superseded by others, then it is incumbent upon us to inquire whether, previous to the adoption of the Constitution, which period or period of passing the law in respect to the object of this inquiry. It is perfectly equal, and actions of this nature like this before the court could have been maintained against one of the states in the Union. Upon the principles of the common law, which I have shown to be alone applicable. If it could, I think it's now maintainable here. If I could not, I think as the law stands at present, it is not maintainable, whatever opinion may be entertained upon that construction of the Constitution, as to the powers of the Congress to authorize such a one. Now I presume it will not be denied that in every state in the Union, previous to the adoption of the Constitution, the only common law principles in regards to suits that were in manner admissible in respect to the claims against the state were those which in England apply to claims against the crown, there being certainly no other principles of the common law which previous to the adoption of this Constitution could in any manner or upon any color apply to the case of a claim against the state in its own courts, where it was solely and completely sovereign in respect to such case at least. They're saying you can't see. Sorry about that. All right, let's try this one more time. Let me just text my moderator back, make sure we good. All right, we're working. Thank you, moderator. Okay, we're dealing with, let's go back here. United States versus O'Keefe, backtrack. As you see here, United States versus O'Keefe, 1870 case, all right? United States. The valuable privilege secured to the subjects of the time of Edward I of the Plantagenet crown is now crystallized in the common law of England as the prayer of the petition is grantable ex debito justice. It is called a petitioner right and is a judicial proceeding to be tried like the suits between subject and subject. All right. Now we know that the House of Stuarts and the time of their colonization and their settlements had something called the petitioner right as well, but they got it from us because the petitioner right extends back to what we call the Magna Carta. All right. It does not exist by virtue of any statute, nor does the recent legislation in England concerning it do more than to regulate the manner of its existence and to confer on the petitioner the privilege not before granted of instituting his proceedings in any one of the superior courts of the common law of equity in Westminster. When we say Westminster, we're not talking about all the European colonies. We're talking about right here, because we just read in Ward versus Keenan that you're able to, a private citizen can do such a thing. The judicial control can be applied in the suit of a private citizen. The private citizen can set motion the different forms of procedures open to the crown. In addition, it didn't say private citizens, it said private citizen. Because the crown can only be represented by one individual, one natural person as a corporation soul. You're going to see that in the same argument in Chisholm versus Georgia as you see it in the United States versus O'Keefe, because they make mention to one natural person representing the king who personifies the crown. All right, Edward the First, I might add, of the Plantagenet crown, son of Henry the Third, son of Henry the Second, son of Godfrey the Fifth, Count of Anjou, where my surname is now from. Let's see. All right, so we just showed you United States versus O'Keefe, Edward the First. Now let's go to Chisholm versus Georgia. All right, because everybody understands, well, the United States is sovereign. They're not sovereign. Attorney General is provincial patriarch of the United States. The state has an attorney general that represents their citizens, and the crown has his. All right? Father of the nation. Let me go a little further. Okay, here we go. The Attorney General has spoken to it in reference to my request, as he has been pleased to imitate, but he spoke to this particular question slightly, conceiving it to be involved in the general one. And after establishing, as he thought, that point, he seemed to consider the other following, of course. He expressed, indeed, some doubt how to prove what appears so plain. It seems to him, if I recollect right, to depend principally on the solution of this simple question: can a state assume? I presume it's presumption in law. All right, that's what it means, presumption in law, in lieu of what we call facts. But the Attorney General must know that in England, certain judicial proceedings not inconsistent with the sovereignty may take place against the crown. But that is an action of assumption will not lie. You hear that? But that an action of assumption will not lie. Ain't no presumptions. A fact is a fact. All right? Yet surely the king can assume as well as a state. So can the United States themselves as well as any state in the Union. Yet the Attorney General himself has taken some pains to show that no action whatever is maintainable against the United States. I shall therefore confine myself as much as possible to the particular question before the court, though everything I have to say upon it will affect every kind of suit, the object of which is to compel the payment of money by the state. The question, as I before observed, is will an action of assumption lie against the state? If it will, it must be by virtue of the Constitution of the United States and of some law of Congress conformable thereto. The part of the Constitution concerning the judicial power is as follows. Article 3, Section 2. Everybody familiar with that? So let's move forward. So yes, they can be sued. Right here. It is therefore this court is to be as can. If therefore this court is to be, as I consider it, the organ of the Constitution and law, not of the Constitution only in respect to the manner of its proceedings, we must receive our directions from the legislator in this particular, and have no rights to constitute ourselves as oscendiae brevium, or to take any other short method of doing what the Constitution has chosen, and in my opinion, with the most perfect propriety, should be done in another manner. But the act of Congress has not been altogether silent upon the subject. The 14th set of the Judicial Act provides in the following words: all the before mentioned courts of the United States shall have the power to issue writs of fides fixae, habeas corpus, and all other writs not specially provided for by the statute, which may be necessary for the exercise of their respective jurisdictions and agreeable to the principles of the uses of the law. Move down a little further. The only principle of law then that can be regarded are those common to all the states. I know of none such which can affect this case, but those that are derived from which is properly termed the common law. A law which I presume is the groundwork of the laws in every state in the Union, and which I consider so far as it is applicable to the peculiar circumstances of the country, and where no special act of legislation controls it, to be enforced in each state as existed in England, unaltered by any statute. At the time of the first settlement of this country, the statutes of England that are enforced in America differ perhaps in all states, and therefore is probable to the common law in each state in some respect different. But it is certain that in regards to any common law principle which can influence the question before us, no alterations have been made by any statute which can associate, which could occasion the least material differences, or have any perpetual partial effect. Nor the part of the common law of England, it appears to me, can have any reference to this subject, but that part in which prescribes remedies against the crown. Every state in the Union, and every instance where its sovereignty has not been delegated to the United States, I consider to be as completely sovereign as the United States are in respect to the powers it surrendered. So the United States are sovereign as to all powers of government actually surrender. Each state in the Union is sovereign as to all the power reserved. It must necessarily be so because the United States have no claim to any authority but such as the states have surrendered to them. Of course, the part not surrendered must remain as it did before. The powers of the general government, either of legislative or executive nature, of which particularly concerns treaties with foreign powers, do for the most part, if not wholly, affect individuals and not states. They require no aid from any state authority. This is the great leading distinction between the old Articles of Confederation and the present Constitution. The judicial executive powers of the general government and the powers which concern treaties. But it also goes further. Where certain parties are concerned, although the subject in controversy does not relate to any other special object of the authority of the general government, wherein separate sovereignties of the states are blended in one common mass of supremacy, yet general government has judicial authority in regards to such subjects of controversy, and the legislature of the United States may pass all laws necessary to give such judicial authority its proper effect. Whatever be the true construction of the Constitution in this particular, whether it is to be construed as intended merely a transfer of jurisdiction from one tribunal to another, or authorizing the legislature to provide laws for the decisions of all the possible controversies in which the state may be involved, which with an individual without regard to any prior exemption, yet it is certain that the legislator has in fact proceeded upon the former supposition and not upon the latter. For besides what I noticed before as to an express reference to the principles and uses of law as the guide of the proceeding, it is observable that in instances like this before the court, this court has a concurrent jurisdiction only. The present being one of those cases where by judicial act, this court has original but not exclusive jurisdiction. The court, therefore, under the act can exercise no authority in such instances, but such authority as from the subject matter as it may be exercised in some other court. Make sure I ain't miss my point. Okay, right here. If therefore a new remedy may be provided as plainly as in the case, as consequently we have no other rule to govern us by the principles of the pre-existing laws, which must remain in force till superseded by others, then it is incumbent upon us to inquire whether the previous to the adoption of the Constitution of the United States of 1789, which was modeled largely after the Constitution of New Jersey of 1844, which was both preceded by the 1776 Constitution, which period of passing the laws in respect to the object of this inquiry is perfectly equal. An action of the nature like this before the court could have been maintained against one of the states in the Union upon the principles of the common law, which I have shown to be alone applicable. If it could, I think it is now maintainable here. And if I could not, I think as to the law stands at present, it is not maintainable, whatever opinion may be entertained upon the construction of the Constitution as the power of the Congress to authorize such a one. Now I presume it would not be denied that in every state in the Union, previous to the adoption of the Constitution, the only common law principles in regard to suits that were in a manner admissible in respect to the claims against the state were those which in England applied to the claims against the Crown, there being certainly no other principles of the common law which previous to the adoption of the Constitution could in any manner upon any color apply to the case of claims against the state of its own courts, where it was solely and completely sovereign in respect to such cases at least, with that remedy was strictly applicable or not, still happening there was no other. The only remedy is in the case like that before the court by which by any possible a suit can be maintained against the Crown of England or could be at the period for which the common law as enforced in America can be derived. I believe it is that which is called a petitioner right, and it is stated indeed that until the time of Edward I, the king might have been sued in all the actions as a common person, and some authorities are cited for that position, though it is even there stated as a doubt, but that the same authority adds, but now none have an action against the king, but one shall be put to suit in him by petition. All right? That's Chisholm versus Georgia, United States versus O'Keefe, two United States cases of the Supreme Court to validate what the district court said in Brothers versus Harris, based on what the Supreme Court said in Ward versus Keenan. All right? So those four cases that I gave you to qualify the power of the authority of the corporation so represented by the crown, i.e. the king, through the certificate of incorporation as required by the statute, as proven in the case we've seen in what was New Mexico. All right, in regard to the Roman Catholic Church being perceived as a corporation soul, which they are not. They are corporation aggregate because they are not natural persons. They don't teach about natural savior or natural God. They teach about an abstract savior or an abstract God, which goes back to the spook God. That's why church and state were separated in the first place. Because under the crown, there was a fusion of power of the executive, legislative, and judicial branches. All right? We all caught up to speed. Let's move forward. Martin versus Waddell. Martin versus Waddell involved property that was allocated to the defendant error who filed a complaint that was on review in the, I think this where's this case at? In the Supreme Court of New Jersey. This is U.S. Supreme Court or United States Supreme Court. Yeah. Martin versus Waddell. So that's three cases from the United Supreme Court in regards to not just remedy sought under the crown by a private citizen, but the remedy sought by the crown for property or return of property in regards to that which was distributed to the state, which is nothing more than a corporation. Why? Because let's go back to Chisholm versus Georgia real quick. I didn't want to miss that. I had a great memory. All right. They're still talking about sovereign immunity and bringing the claim under the crown. All right. And you know, a king cannot be sued in his own court. So if the court represented by the king bench as the authoritative figure under in which the king's been sentenced in the king's court, all right, which is ran by what we call either the Parliament of England. Prior to that, it was called the Career Regents, or prior to that, it was called Wittemont. It all deals with a letter patent, and a letter patent deals with the authority to have a charter granting a right or privileges or use, i.e., called a prescription right, a right of use, a non-possessory right and use of property that to belong to you, because all property belongs to the crown. That means that all property is a allodial, all right? Intel, all right? So it says here in regards to that sovereign immunity of the crown, because the crown is sovereign. Corporate actors are not sovereign, all right? They can be sued by either their state statute or, as we see it under the federal government, Article 3, Section 2, because they are corporations. How United States, how we know it, United States is going to say so in regards to the difference between the United States Constitution and the Constitution of the Articles of Confederation, which was subject to the crown at that particular time. All right? Through the Articles of Confederations, which is nothing more than the Articles of Alliance or the Articles of Amity and Commerce, because it was just an agreement for commerce. All right? Nothing more for the king's behalf. All right, let's get busy. There is no other part of the common law besides that which have considered, which can be any person be pretended in any manner to apply to this case by that which concerns corporations. The applicability of this, the Attorney General, with great candor, has expressly weighed. I wonder why. But as he may be urged in other cases, and as I wish to give the fullest satisfaction, I will say a few words to the doctrine. Suppose, therefore, it should be objected that the reason I have now used is not conclusive, because, inasmuch as a state is made subject to the judicial power of Congress, its sovereignty must not stand in the way of a proper exercise of that power. And therefore, in all cases, Article 3, Section 2, though in no other, a state can only be considered as a subordinate corporation merely. First answer. First, that this construction can only be allowed at the utmost upon the supposition that the judicial authority of the United States, as in respect states, cannot be effectuated without proceedings against them in that light, a position I by no means admit. Second, that according to the principles I have supported in this argument, admitting that states ought to be so considered for that purpose, an act of the legislature is necessary to give effect to such a construction, unless the old doctrine concerning corporations will naturally apply to this particular case, i.e., letter patent versus statutory incorporation. Yes, I am statutory incorporated, but the statutory incorporation was based off the charter given through the letter patent that originated from the original king. All right, going back to my forefathers, and being that I'm heir to the certificate of corporation as originated from the original charters, being that I am an heir, I have the right to incorporate as corporations. So, which none of them took the auspices to do it. The only one that did it was the Roman Catholic Church, which all those who descended from the House of Stuarts back to the House of Tudors all got their authority and instructions from the Roman Catholic Church. All right? That's it. Third, that as it is evidence, the Act of Congress has not made any special provisions in this case, grounded on any such constructions. So it is, to my mind, perfectly clear that we have no authority upon any supposed analogy between the two cases to apply the common doctrine concerning corporations to the important case now before the court. You hear that? I take it for the granted that when any party of an ancient law is to be applied to a new case, the circumstances of the new case must agree in all essential points with the circumstances of the old cases, i.e., the old depositories of the old judiciary decisions of the old case laws decided by the old judges, all right, to which that ancient law was formally appropriated. Now there are, in my opinion, the most essential differences between old cases of corporations to which the law intimated has reference, and the great and extraordinary cases of states separately possessing as to everything simply relating to themselves, the fullest power of sovereignty, yet in some other defined particulars subject to the superior power composed out of themselves for the common welfare of the whole. The only law concerning corporations is to which I can see the least reference to is to be that is the common law of England as that subject on that subject. I need not repeat the observation I made in respect to the operations of that law in this country. You hear that? In this country. The word corporation, in its largest sense, has more extensive meaning than people generally are aware of. Any body of politics, sole or aggregate, whether its powers be restricted or transcended, is in a sense a corporation. The king, accordingly, in England is called a corporation. So also by a very respectable author is the parliament itself. It is this extensive sense, not only each state singly, but even the United States may, without impropriety, be termed a corporation. I had therefore, in contradiction to the large and indefinite term, used the term subordinate corporation, meaning to refer to such only as alone capable of the slightest application for the purpose of the objection, which creation of whose powers are limited by law, i.e. statute. The difference between such corporations and the several states in the Union as relative to the general government are very obvious in the following particulars. First, a corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. This is a result of the English Civil War between the crown and parliament. It owes its existence, its name, its laws, except such laws that are necessarily incident to all corporations merely as such, to the authority which created it. A state does not owe its origin to the government of the United States in the highest or in any of its branches. It was in existence before it. Once again, it was in existence before it. It derived its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. Second, a corporation can do no act but what is subject to the revision either of a court of justice or of some other authority within the government. A state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority unless in special instances where the general government has power derived from the Constitution itself. Third, corporations are altogether dependent on that government to which it owes its existence. Its charters may be forfeited by abuse. Its authority may be annihilated without abuse by the act of the legislative body. A state, though subject in certain specified particulars to the authority of the government of the United States, is in every other respect totally independent of it. The people of the state created the people of the state can only change its constitution. Upon this power, there is no other limitation but that imposed by the Constitution of the United States, that it must be a republic form. Did you hear that? So understand the power of the Constitution, which was subverted from the original Constitution under the Articles of Confederation, which came or extended from that of the concession agreement of the proprietors, which was surrendered back to the crown in 1702. So therefore, anything prior to that is a violation of law. How? Let's prove it in closing. Martin versus Waddell. Ward versus Martin versus Waddell, United States Supreme Court. All right. Everybody who's watching this video are required to leave a comment. A comment if you agree, you like the video, you don't like it, any remarks to the video, but you must leave a comment. Okay, so if you leave a comment, I can address those issues and clear those issues up. Because I'm trying to bring you into the temple. Because once those doors open, and you don't understand that, because the doors are open. You know what I'm saying? The doors are open. All right. I'm going to qualify by this. All right. These issues are being raised, and the district court can do nothing about it because they know I'm right. And ultimately, it's going to get to the head, United States Supreme Court, because I'm using the Supreme Court to validate that everything is happening that's happening in the district court as a result of what the state courts are not doing, which they were obligated by the Supreme Court. All right, which they're supposed to be representing the king's bench and dealing with the king's prerogatives through the prerogatives that set forth by the king, which they were called out there because now they don't exercise such a power as establishing Villain versus Harris. All right. Let's read it in closing. How many people you can turn in any channel right now on YouTube and review the content that you hear on YouTube? I don't care if it's for your fancy, for learning experience, for enjoyment, just to gossip. But look at the state of mind that you are in as a result of your response of what you perceive based off your perception. All right. I'll talk about transduction. All right. To be able to make sense of cellular signals. All right. Perception of your cellular signals, because I'm giving you the ability to achieve biological immortality through memories of that information that was stored in your cells. All right, going back to your ancestors who are in existence right here because they achieve biological immortality. All right, nothing spook about it. The Europeans of the classification as established here for citizenship as classified by the citizens under the colonies through the Confederate States under the Articles of Confederation, now called the United States Constitution, are still filling the same requirement they had through the Naturalization Act and require their status. So what is your status? Because the status for their status and every other status was the English status, all right, which was in conflict with the Scottish and the Frankish through the alliances that were made with the Frankish and the Scottish, as well as those who abandoned that English obligation in regards to their allegiance. This is about your allegiance. All right? Martin versus Waddell goes back to an argument in regards to charges given by receivers of what we call a certificate of title, or what we call a tax deed, a warranty deed, or fee and simple deed. Any deed what you have in your possession right now is only by way of prescription. It only comes by way of the eminent domain power of the state, by way of properties being exceeded to the state by way of what we call police powers. All right? Under the police powers, the land falls under what we call public domain. This is case deal with the public domain doctrine. Okay? Property that's hands off. Look up public domain property, and they're going to give you this case in regards to the review of the Supreme Court. But the origin and the decision of the Supreme Court based off this case goes back to the kings of England. Y'all don't hear me. You're standing in England right now. because all the deeds that were issued by the houses and stores under the Treaty of Westminster, under the Treaty of Perpetual Peace, as well as the treaties of those alliances made with the Frankish and Scottish and the rebellious descendants that broke away through the Lancasters and the Yorks conflict amongst themselves under the fight for the English crown, is all over this position or office of the crown. It's what it's all about. So here is the conclusion or the end result of the person who fits that description to sit in that seat of the office of the crown called corporation sole. Oh, I missed something. Where is that at? I don't think I read it. Ooh, thank God I remember this. The elders don't want me to miss nothing. Here we go. All right, there we go. They know full well what's going on. Everybody see this. So don't say you either turn your head or bear witness to the truth. Tell me who has been able to do this on behalf of the King of England and the King's subject, because you're reading it for yourself in 1793. The difference between the United States, which they just said in the case, is a subordinate corporation, an aggregate, and they know the difference. The only law concerning corporations to which I can see the least reference is to be had is the common law of England on that subject. I need not repeat the observation I made in respect to the operation of that law in this country. The word corporation is the largest sense, has a more extensive meaning than people generally are aware of. And any body politic, sole or aggregate, whether it's the power be restricted or transcendent. So right there, they tell you they know the difference between the corporation sole and aggregate. They chose an aggregate contrast to sole. You see that? Contrast to sole. All right. So back to Martin versus Waddell. All right. This is contrast to the letter patents that were given to the profiteers, George Carteret and John Berkeley, off a letter patent given from York, the brother of Charles II, who received the territories through the Treaty of Westminster of 1674. All right. When the Dutch surrendered New Amsterdam. All right. All the Dutch Swedish territory going back to the 1654 territory was succeeded back to the House of Stuarts. All right. The House of Stuarts were in succession, and that territory was succeeded back to the crown, as them sitting on the monarch through the union of the crown in 1503. And we know that the parliaments or the government was separate. All right. And the only thing we mention here is the Kingdom of England. It didn't say the Scottish government or the Irish government or the United Kingdom. They're talking about the English government here in 1842, as well as in 1980, as well as in 1798. I mean, come on now. This is crazy. Let's read it. That although the king is the owner of this great coast, and once again, this case is about profiteers getting territory from the people are claiming a right to parcels of land here in North America. Because when you claim property, it's a parcel of land. It's not a lodium. You only get a parcel. That's what you call real estate, an interest in an estate. All right. So this practice was inherited by the colonizers who colonized what we call the 13 colonies, based off the land grants that were given. All right. We know South Jersey, the southern colonies, the middle colonies, and the eastern colonies. The southern colonies was based off those that were under the authority of the House of Stuart, going back to Elizabeth's colonization. All right, St. Augustine. The middle colonies comes under what we call the wars between the wars of the Dutch, but they all was under the authority of the auspices that were fought as a result of the power given by the treaties of perpetual peace from 1503 to 1534, which involves the Treaty of Westminster through the House of Lancaster under Henry VIII, right? With the Scottish kings, King James V and King James IV. All right? This is amazing. I know this. Okay. So it says that although the king is the owner of the great coast and as consequent of his propriety, has the primary right of fishing in the sea, in creeks and arms thereof. Yet the common people, I'm sorry. Right here, everybody. Yet the common people of England have regularly a liberty of fishing in the sea or creeks or arms thereof as a public common of piscary, and may not without injury to their rights be restrained of it unless in such places, creeks, or navigational rivers, where either the king of some particular subject has gained propriety exclusive of that common liberty. And as we see in this case, as well as Johnson versus McIntosh, all right? We can see it in other cases as well, but for the sake of time, I'm not going to go through them. The principles here stated by Hale as to the public common of piscary belonging to the common people of England is not questioned by any English writer upon the subject. The point upon which different opinions have been expressed is whether, since the Magna Carta, either the king or any particular subject can gain a propriety exclusive of the common liberty. For undoubtedly, rights of fishery exclusive of the common liberty are at this day held and enjoyed by private individuals under ancient grants. But the existence of a doubt as to the right of the king to make such a grant after the Magna Carta would of itself show how fixed had been the policies of that government on this subject for the last 600 years, and how carefully it has preserved this common right for the benefit of the public. Y'all don't hear me. Y'all do not hear me. This is going to get to the United States Supreme Court, where we're reading from on all 7 cases I got filed in the district court. Why? Because the United States, as well as the state courts through the United States Supreme Court, have bailed out, they have committed treason, they have broken their allegiance under the Articles of Confederation. All right? Hear me now. You are in the King's Court right now. And there is nothing in the charter before us indicating that a different and opposite line of policy was designed to be adopted in that colony. On the contrary, after enumerating in the clause herein before quoted, some of the prerogative rights annexed to the crown, but not all of them, general words are used, conveying all estates, rights, titles, interests, benefits, advantages, claims, and demand of the king in the lands and premises before granted. The estates and rights of the king passed to the dukes in some condition in which they have been held by the crown. You hear that? So all those who are making claims to rights to property by way of grants given by proprietors. It was given in lieu of private individual right. It was based off those rights granted by the crown for the creation of a government under the municipal government of England, governed under the crown. That was his purpose. That was his intent. That was his nature, and that it was perpetual. Okay, and upon the same held by the crown, and upon the same trust, whatever was held by the king as prerogative right passed to the dukes in that same character. And if the word shall be appropriated word to pass lands covered with navigable waters as contended for one of the parts of the defendant in error, it is associated in letter pads with other royalties and conveyed as such. No words are used for the purpose of separating them from the jury gallia and the converting them into a private property to be held and enjoyed by the dukes apart from the independent of the political character with which he was clothed by the same instrument. Upon a different construction of what it would have been impossible for him to have complied with the conditions of the grant. You hear that? For it was expressly enjoined upon him as a duty in the government he was about to establish, to make it as near as might be agreeable in their new circumstances to the laws and statutes of England. And how could this be done if in the charter itself this high prerogative trust was severed from the regal authority? Did you hear that? Is inalienable. If the shores and the rivers and the bays and arms of the sea and the lands under them, instead of being held as a public trust for the benefit of the whole community, to be freely used by all for navigation and fishery, as well as for shellfish as floating fish, had been converted by the charter into itself into private property to be parceled out and sold by the dukes for his own individual emolument. Did you hear that? Parceled out and sold by the dukes for his own individual emoluments. Question mark. There is nothing we think in the terms of the letter patent, nor in the purposes for which it was granted, that would justify this construction. And in the judgment of the court, the lands under the navigable waters passed to the grantees as one of the royalties incidents to the power of the government, and were to be held by him in the same manner and for the same purpose that the navigable waters of England and the soils under them are held by the crown. I know this got to be resonating with y'all. I know this has to be resonating with y'all. All right? It has to. You have to wake up because you will be judged accordingly. All right? This is what the Supreme Court of New Jersey said until it was put before them in front of them. They just didn't say they couldn't deal with prerogative rich because it was superseded by the Constitution of 1947, and now the power as invested by the amending of the Constitution legislatively to a statutory coded law that it was put under Article New Jersey Revised Statute, New Jersey Court Rule 4:69-1, which is the remedy sought forth, and the Superior Court, which is a right, not a granted privilege. It's a right. That was a violation of law. And they knew that because in my writ of mandamus quo warranto, I wrote those writ of mandamus under the jury gallery as the king. So that's the reason why they dismissed the petition for certification, because their allegiance was in question. It was in question at that very moment. And Villain versus Harris qualifies it because the legislature was powerless to cut away the prerogatives that the king had under his auspices, under his arsenal. All right? Which I was exercising because Chief Justice Vanderbilt said that it was the private right of a private individual to call in the power of the crown as the ultimate power to keep things or keep the administrative agencies at bay, because they're dealing with the review of administrative agencies which are governing the land right now. All right, so in closing, this opinion is confirmed by referring to similar grants for other tracts of country upon this continent, made about the same period of time. Various other charters for large territories on the Atlantic coast were granted by different monarchs of the Stuart dynasty to different persons for the purpose of settlement and colonization. Did you hear that, y'all? Did you hear that? In which the powers of government were united with the grant of territory. Some of these charters were nearly resembled in every respect to the one now in controversy, and none of them, it is believed, differed materially from it in the terms in which the bays, rivers, and the arms of the sea and the souls under them which were conveyed to the grantees. Yet it is no one of these colonies, yet in no one of these colonies has the soil under the navigable waters and the right of fishery for shellfish or floating fish been severed by the letter pattern from the power of the government. In all of them, from the time of the settlement to the present day, the previous habits and uses of the colonists have been respected, and they have been accustomed to the enjoyment of enjoyment accustomed to enjoy in common the benefits and advantages of the navigation of waters for the same purpose and the same extent that they had been used in enjoyment for centuries in England. All right. Indeed, it could not well have been otherwise, for the men who first formed the English settlement could not have been expected to encounter the many hardships that unavoidably attended their immigration to the New World, and to the people, the banks of its bays, and the rivers and the lands under the waters, and their water doors were liable to immediate appropriation by another as a private property. All right. So this is the story with the Native American. All right, they were considered mere occupants of the land because there was no such thing as a Native American, because a Native American was turned by American Vespucians who came over to the Rise of Discovery, and to the time of discovery to the 14th century, and where you get into the Anglo-French wars, as well as the wars dealing with the Frankish and English kings under Henry VIII and Francis I. All right, which goes back to the territory called Louisiana, which is Mississippi encompasses, where my forefathers come from. My grandfather, my great-grandfather, my grandmother, my great-grandmother, which name was Ruth, both of them name were, and my father's last name was Jefferson, and Jefferson is a title of nobility, all right, which they didn't have. And we know that because Thomas Jefferson naturalization processes did not go to that of what we call genetic or ethnicity or genealogy. Why? Because it wasn't based off that. It was based off a color of skin. These are facts. All right. Let's go to my closing. Let's see. Let's get something. Just to make sure I ain't forgetting nothing. All right. Like, once again, this deals with the charges given from Charles II to Duke of York, which were recalled by way of legislative statute, New Jersey Revised Statute 46, colon 3-1. All right. I'll end with that. And then had y'all long enough. All right. In closing, I can discover nothing in the authorities giving countenance. So this whole case, the Supreme Court is talking about both parties' argument in lieu of the review, and let them know that they are both in error. They're both in error. You know what I'm saying? Because the United States don't have no claim, nor do the states have a claim in lieu of arguments in regards to the crown, because right now they're just taking care of abandoned property, which comes under what we call police powers of the state. Until some as abandoned property, until somebody can claim it. The only person who can claim it is the king. We're reading it. Let's read it for ourselves. I can discover nothing in the authorities giving countenance to the idea that the king held the land covered by the waters of the navigational river as trustees or by the tenure different from that by which he held the dry land. And I must again repeat, it is the king. If the king held such land as trustees for the common benefit of all his subjects and inalienable as private property, I am unable now we're talking about private property. Okay? The private property that was assumed by the parties in this case, as well as how they got the property by way of the assumed deed or a certificate or the letter patent, was contrary to how the king established it, which has come to bold face, which has come to fruition, which is the argument that they're dealing with right now. All right? Because we're talking about New Jersey. All right? I must again repeat, the king held such land as trustee for the common benefit of all his subjects, and it is eligible as private property. I am able to discover on what grounds the state of New Jersey can hold the lands discharged of such trust and can assume to dispose of it to a private and exclusive use of an individual's, i.e. aggregate. If it was a trust estate and the king for the benefit of its subjects, and upon the revolution, the government of New Jersey became the trustees in the place of the king, and the trust devolved upon such government, and the land became as inalienable to the government of New Jersey as in the hands of the king, and the state must be bound to hold all such land subject to the trust, which is contended embraces a common right of fishery in the waters, and the dredging or oysters in the land covered by the waters. And if this be so, there certainly can be no power in the state without a breach of trust to deprive the citizens of New Jersey of such a common right and convert these oyster grounds to a private and exclusive use of an individual. There is nothing in the case, in my judgment, showing a uses in the state by which the proprietors have either directly or by implication relinquished or abandoned any right of property which they derive under the charters of Charles II. All the authorities exercised by the state in granting ferries, bridges, turnpikes, railroads, etc., are the exercise of the power vested in the government over private property for the public use, i.e., public domain, and for a part of the powers of the government surrendered by the proprietors to the Queen. And it's the only sense decision in Arnold versus Mondi that the private right of the proprietors to this land under the waters of New Jersey have been denied and assumed by the state to grant to the same individuals, and even in such cases has been done cautiously and apparently with hesitation as to the right of the state. All right, that brings me to here. Once again, special thanks to my moderator, Archbishop Belmont from the House of Belmont. I expect a comment from you, Noble. Oh, come on. I'm all getting bombarded now. Feudal tenure. Feudal tenure started from William the Conqueror. All right, these are fee simple estates. The fee continuous estates and interests thereof are taken away, discharged, and abolished. Let's get an updated, newer version. 2022. The feudal tenure estates and interests thereof The feudal tenure states and instances thereof taken away, discharged, and abolished from after March 12, 1664. March 12, 1664 was under the authority of the crown because the province of New Jersey was from 1664 to 1776 under the provisional crown when the provinces surrendered authority back to the crown in 1702. Prior to that, it was under George Carteret and John Berkeley. And John Berkeley got their charter on March 12, 1664 by way of a charter given to Duke of York. And that was surrendered back to the crown. So it became crown authority, all right, because all feudal tenure has been abolished, all right, discharged and abolished, no such an instance thereof shall at any time be created in the manner thereof. That brings me here. (46:3-2). This is corporation sold. The tenures and honors, manors, lands, tenements, inherited tenements, or of states of inheritance at the common law held either of the King of England or any other person. So any other person at any time could have done what I've done. All right? Or body of politics, because the king is head of the body of politics through incorporation. That's how everybody else did it. Right? And the king personifies the government as the crown because the crown is the corporation's soul. All right? And the crown is incorporated and instilled with the body of politics, i.e., the polity, a fusion of government as it was in the days of the province of provincial council, a fusion of a government versus or contrast to a separation of church and state. All right? At any time before July 4th, 1776. This is what became a corporate aggregate with the United States colonies that were the colonies before they became states. All right, when they declared their independence from Great Britain on July 4th, 1776 Constitution, but the common law of England was still in force at that time. Right? So they say that an act concerning those tenures, as stated in 46:3-1, that passed on February 18th, 1995, was it? 795, is to return into holding of free and common socket from the time of their creation forever thereafter, and shall continue to be held on free and common sockets, discharged of all tenure charges and instances enumerated in said section thereof. That what represents the crown. The concept of crown is when all land is succeeded because there are no heirs and automatically succeeds to what we call the crown, which is represented by the king. All right. That means that all land that's parceled out by the House of Stuart or any king that got their authority, gave the authority to the House of Stuart, such as Henry VIII, is not their true authority because those grants or letter patents or charges can be questioned because it'll be read in the case the authority of petitioner right in regards to land and the right of ownership of land goes back to petitioner right that go back to what we call the Magna Carta. Okay, the Magna Carta. All right, bring me to this statute. Gift grants conveyances by the state of New Jersey are allodial. All gifts, grants, or conveyances made prior to and after July 4th, 1776. So before they declared their independence and after they declared their independence, any estate, whether it was a grant, whether it was a gift, whether it was a result of what we call non-possessory use by way of what we call incorporating and do your certificate or a deed filed with the county as a form of a conveyance of some assurance of some property,
'made after or prior to July 4th, 1776,
of any estate of inheritance by letter patent under the great seal of the state or any other manner by the state, by the legislature thereof, by the commissioner or agents forfeited the state, or by lawful and competent authority under the state, shall be and remain allodium, and no fiddle or shall forever be and continue and be pure allodium only, forever of all field tenures and the interest thereof and all other services whatsoever. That's 2022. Let's see a newer version of it. Right there. Same thing. So in closing, I'm going to show you what they're trying to do, which I've shown you so many times, but I'm going to show you now. It's too late, though, because this is evidence. This is receipts, y'all. This is a record. I'm showing you a record. Everything I'm showing you is being brought forth and argued in the court. Including this, in closing. Everybody see this? State of New Jersey Law Review Commission, their job is to go in to take a look at statutes that are soon to be outdated, anachronistic, or abuse or those that are of no more use. All right, it says right here, and I quote. Right here. There are a great many provisions of the current law that have been deleted from this draft. The table disposition indicates that these sections have been deleted. It is our judgment that these sections are unnecessary. Many are clearly what we call anachronistic, meaning that they're of no use. They don't make sense anymore. I even had in one of the cases I got that I think dealing with the property, that the defendant wanted the case dismissed as being anachronistic, and the court denied it. They denied it, their dismissal based off those grounds. All right. Let me see here. All right, everybody see that? Some of the same statutory law that you just seen that are still in the statute, they were brought forth to the legislature for repeal, but they couldn't repeal them. All right. This is their review that was submitted before the Law Review Commission in regards to the anachronistic and the statutory law, because they're assuming that they're not applicable. But these are the laws governing our state that they're trying to act like they're not applicable, which I'm proving that they are, because the current statute has now going to be revised into these statutes here on the right side versus those on the left side. All right? 46.3-1, 46.3-2, 46.3-6, 46.3-10 deal with the common recovery practice that turns our inter-estate interference, which was the practice used to steal it in the first place. All right? There's laws govern that. I already spoke about that, so I'm not going to get into that. But with that, I'm going to go back right here to Waddell versus Harris before I close. It says New Jersey's first constitution, adopted July 7, 1776, terminated its status as an English colony and began its sovereignty existence as a state. Article 22 of the Constitution contains the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely in structure and the content of the Constitution of the United States. Very important. Article 10, paragraph 1, it too continued in the force of the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, Paragraph 3, continued to enforce the existing laws of the common law of England. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench. In 1844, it's modeled after the United States Constitution. So therefore, the Supreme Court of the United States is going to oppose the Supreme Court authority that they were embedded with, that the legislature was powerless to sever, versus what we're reading here. It said, and which the legislature was powerless to cut down or to assign to other courts, and which we show you they have did in regard to the communication with the Supreme Court of New Jersey in regards to my core warranto and writ of mandamus, and as well as my written circulator. They didn't want to pull those records. They know if they pull those records, it's going to be some problem. So they didn't want to give me the long, the short road. They want me to take the long ride. All right. We're in the movie to give them the long ride, boss. But this is going to work out in our favor. All right. So as we see here, that the Constitution of 1844, preceded by the Constitution of 1776, was vested with all the power of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. So no matter what court you're in, if they're not operating under the authority of the King's Bench and the circuit courts of the King's Bench, then they're out of order. This principle was especially strong in fields of prerogative which writ of circulator was the most frequently sought, which was denied by the Supreme Court of New Jersey, which is in question now as a result of their obligation to abide by that Constitution, all three Constitutions of 1789, 1844, and 1776. So with that, I stop my share. And, all this I do for you. I know it was a beautiful lecture. You can't tell me it wasn't, even if you don't leave a post. I hope that you do. To show me, your gratitude. Like I said, those who are able to donate, please hit up $ Clifford Jefferson L on what we call what you call it? What they call that? Not Zelle. They call that. 1 second. Cash App. Not that that's my focal point, but like we said, all gifts, all grants as required by the statute are required as free and common soakage. So if we can give common soakage to those who under feudal tenure obligate you by way of threat, duress, and coercion, surely you can pay homage to me, because I'm trying to free you from that. And my reward is with me for all those who are subject to the crown. And with that, as always, the English Church of England, under Magna Carta, Article 4, we say